Good evening, everybody. Welcome to Good Lawgic Players Edition, where we do live reads of transcripts from actual court proceedings. And tonight, we are going to be doing day 2 from the cross-examination of admitted perjurer, Michael Cohen. When you have cross-examination of an admitted perjurer, there's a lot of fodder. And from what we've seen in all the reports, he did not do too well. This was what many consider to be Donald Trump's best day. So I'm sure there's going to be a lot of juicy moments here. Some we've seen, some we may not have seen. And I'm going to bring onto the stage, first and foremost, my friend here, Southern Law Steve. How are you, my brother? All
right, Joe. Good to be here. My natural habitat of pretend to know something.
you are actually one of my favorite people, one of my favorite law tubers. I know that you're not doing much work of late, but I'm gonna tell you right now, that needs to change, because you really are. You're someone who is not just in providing intelligent insight, but I've spent enough time around LawTube to know that you're certainly upper echelon as far as being salt of the earth, good human. And
well, thank you.
And I'm a really good judge of character. And I'm telling you right now, I'm telling my audience right now, there are very few people amongst the law 2 genre who are as genuinely a good person as Southern Law. So please make sure you guys sub up to him, support him in any way possible. He's an awesome guy, a phenomenal attorney, and great content creator. So I thank you for joining me. I'm honored to have you here, and we have a new player entering the field who I sent a link to. I offered to so many people, do you want to come? I said, if you want to come, let me know. And they were like, and so many people came back and was like, yeah, I want to come in. And then, like, I guess I figured they would get 10 hours notice, and I gave them 20 minutes notice, and no one actually has hit me back yet, except for this individual here, Starlight.
Hello.
Hey, how are you?
Pretty good. That was 10 minutes, Joe.
It was 10 minutes. 10 minutes. I missed you. I had missed, yeah. I'm liking the whole April from Parks and Recreation vibe that I'm getting from you. I'm really enjoying it. I'm not kidding you.
Yeah, so, we're going to have a Southern evening.
All right. Oh, are you Southern also?
Yeah, I'm from South Carolina.
Oh, beautiful.
The second best Carolina.
Shiloh did offer, but I was trying to bring in new, if it's someone who everyone knows, so then I'm happy to but if I can get players, but if it's people who aren't really having YouTube channels, I feel I want to sort of share around. I think that's I appreciate you offering, Shiloh. All right, so we're definitely putting Southern Law in the role of Michael Cohen.
Of course.
Yes. I'm loving his New Jersey accent. Starlight, would you rather the role? I'm probably gonna take Todd Blanche just because I feel there's a lot I'm gonna be able to read it through as a lawyer would and be aggressive and whatever. So my question is, would you prefer the role of Judge Merchan, or would you prefer the role of the prosecutor?
Whichever one. I just did half of Stormy Daniels right there. Yes.
Nice.
Yes.
Okay, so you know what? I'm gonna be gender consistent tonight. Miss Hoffinger is prosecutor, so we're gonna throw you in the role of the prosecutor, Miss Hoffinger. All right. So you're gonna take her role here, and let me see if I got a quick anyone who hit me back as far as being interested in joining. Let's see you hit me back, but let me see if there's anyone else here. I don't see anyone else. All right, you know what? I'm going to step into the role of, I guess, Merchan. That's the best way to do it. I don't know. Hopefully, if someone wants to join in here and hit me up, I'd love to bring them in here. Master Phillips, hitting up the king of recruitment, of Good Lawgic recruitment, bringing in 10, count them, 10 Good Lawgic memberships. God bless you.
Nice.
Awesome start to this show. I love when we start with new members who are being brought into the fold.
The following program
That
is recorded with a 5-second delay.
That's not right.
In the event of something truly
To the
horrific,
fold.
the following program, the
Oh my
host
God.
has 5 seconds to
Clean
calmly
myself
interrupt the
first.
flow of the stream and prevent the
Wow, that was a nightmare. Whew. Okay. All right. He actually, what I see here is he gifted. Let me make sure. Did he do that once? He did that twice. I think he did it once, but it looks like it's showing us twice here. So, welcome to the following. Jenna Starlight, you got a membership.
Oh, thank you.
Yeah, there you go. From the disciple, gifted you with a membership. Cedar Rose, JG, Luke B, T Renee, Trooper Dog, Peanuts, Nana, Pitchlock, and Maybe Sunshine. All of them. Welcome to the following. The following is not at all a cult type of cult. People like Starlight over here might be very confused. You might say to yourself, "Who's the leader of the following, Starlight?" Who is?
Worcester.
Thank you. Not me. You see? Worcestershire, leader of the following. I am not the leader of the following. And not that there's any shame for Worcestershire being the leader of the following, because the following is not in any way a cult type of cult at all. It's not at all. I am not the leader of the following. Say it with me. Joe is not the leader of the following. We say it twice to make sure it's crystal clear. And like I said, not at all a cult type of cult. There's no self-harm, no harming others, no spaceships, no tracksuits that are mandatory, no Kool-Aid, no self-harm, no harming others, no stabbing yourself with the jabby jab, no dancing around bonfires while shotgun clothing to the beat of a tom-tom in the middle of some forest, no squirrel mutilations, no goat sacrifices, no throwing virgins into volcanoes. No way, shape, or form is this not. Sorry, it's not at all. We're all clear. We're all clear on that. We have a lot of ground to cover. So we're going to move in and do this as efficiently as we can. And without further ado, Good Lawgic Players Association brings to you my fellow. There you go. Action.
Take one.
Take one. We start off with you, Miss Hoffinger. I guess. Is that where we're starting? Yeah, there we go. 21 says sidebar discussion. Go for it.
We have additional objections at this time, Judge.
Do you want it to happen in open court?
I think I would rather that we remain at sidebar, but unless you prefer to do it in open court, you can decide once I explain.
The press doesn't like it very much.
They will be able to read it later, I would assume, Your Honor. Based on defense counsel's proposed jury changes, we understand that they will likely be asking Mr. Cohen today about Judge Furman's recent decision in the Southern District of New York. We understand that he may be able to inquire about it, but we would object to the decision going in as being extrinsic and collateral. Also, we do think that if they go into that, meaning Judge Furman's decision, not what he testified to, that we would be on redirect seeking to admit Judge Ingeron's decision about that testimony. So I just wanted to preview that. A couple of other things just before the testimony continues. I don't know if we can do this before. Wait a minute, I lost my place. I don't know if we can do this on the fly as we go. So I wanted to preview it for the court. Defense counsel provided us with a number of exhibits. As you know, you may not know, there were some clips on Tuesday, but now there are, I may be wrong, but maybe close to 50 clips relating to Mr. Cohen's either TikTok or other podcast programs. We have only the full clips. I asked for the full clips for some of the exhibits that Mr. Blanche told me he was going to seek to admit. We don't have the full clips for the others, but I didn't know that he was seeking to admit them. He may be seeking to use them. Of course, the witness may not really be able to determine what else was said on the podcast, but we do have some very specific objections for some of the clips that Mr. Blanche may seek to admit. One is that there has been significant testimony about Mr. Cohen's bias.
About what?
Mr. Cohen's bias, you know, his hostility towards the defendant, his making money off of the defendant, and we did not even object to the exhibit relating to some of his merchandise. We felt that it was going to come in any event, but in that merchandise there are some pictures of the defendant behind bars in an orange jumpsuit. Enough of that has come in at this point. A number of these clips we think are precluded by Your Honor's decision on the motion, on the people's motion in limine, which is they reference opinions about whether he should be in jail, whether he should be in handcuffs, whether he should have a mugshot taken. First, our office did not take any mugshots, did not take fingerprints. Mr. Cohen probably is not aware of that. It's not something that he may or may not be aware of. But at this point, we really think that this is intended to elicit something quite improper for the jury. And so B35, just to go over a few of them, B35, the other thing is that they were taken out of context. So, for example, B35 had Mr. Cohen talking about, you know, something like mental excitement about seeing him in an orange jumpsuit, which is what they have excerpted. But what they haven't included is just before that clip and just after that clip is saying that's not appropriate. That's not what we should be wanting. What we want is accountability. We should be seeking only accountability. We should be seeking due process, a fair jury, a fair judge. So the context has been excerpted out of that. We are left with an excerpt of a clip talking about excitement about seeing him in a jumpsuit, which again, we think Your Honor has precluded evidence of potential punishment or consequences in this proceeding. So, if that is admitted, we object to it, because if it's admitted, we are going to seek on redirect to submit the clip in its context. And there are other clips. The other clips are similar in many ways: perp walk, handcuffs, etc.
Your Honor, we provided all the clips to the defense, most of them.
To the prosecution.
Thank you. He misspoke and said defense. He meant to say prosecution. Thank you.
That's okay. That's all right. I feel the same way sometimes.
To the prosecution, most of them on Tuesday, more yesterday. We're not seeking to offer virtually any of them. They're just to refresh his recollection. Now, the people are correct. There are a few that we want to offer. Look, the law, I don't need to pass it up to the court, but evidence of bias is always admissible and extremely important. And extrinsic evidence of bias is always admissible. And of course, the court can limit it appropriately. And we're being judicious in our view. And we are not offering 50 clips of him saying things. We have a handful that are targeted at his actual, in our view, his actual bias. We're talking about, I believe we're seeking to actually admit 3 or 4, maybe 5 short clips. That is out of hundreds that we could potentially seek to admit. So evidence of bias is admissible. We have a ton of evidence of bias. We're seeking to admit extrinsic evidence of bias, which we're allowed to do, and a handful of cases. That's fine. This is where you need a 4th person, right? But it appears that you're taking that out of context. I have certainly no problem with the people going back into it on redirect, sure. And showing that you took it out of context. Your Honor, I very much appreciate that there's evidence out there that from Mr. Cohen that they would want to offer on redirect. And them stating that I'm opening the door to his bias, I'm not suggesting he's opening the door for the evidence. You know what? Maybe we should do it like this. Maybe Southern law. Maybe if you're gonna be doing like an accent, like a Jersey accent for Cohen, maybe you'll do the court. That way, there's more, because there's gonna be very little interaction between Cohen and the court. So maybe it's best if you play both roles of Judge Merchan and Cohen. Does that make sense?
So I will be the court.
Yeah, do your normal voice for the court, and do like your best Jersey accent for Michael Cohen. Does that work?
Of course.
All right, but now you're the court. So we're up over here with you.
Regarding Judge Furman's decision, are you going to bring that out?
No, but I don't know how he's going to answer questions. What I intend to ask him about is what happened with the AI case, the situation, and it's just that what happened, and then ultimately ask, like I'm doing for all of his attempts to get out of supervised release early, just ask whether that was denied and not ask. I'm not asking about anything about his findings or anything.
Okay.
Because I believe that that's not allowed. It's just not, the Engeron finding is not allowed.
All right.
Just two other things. I apologize. From one of the clips that they are offering talks about Mr. Cohen from 2020. Talks about Mr. Cohen's the cases that are the investigations that he believes are out there, meaning the Southern District investigation and the OAG investigation and an investigation by our office. And he talks about speaking with our office about all sorts of financial crimes. So if that does come in, that does open the door, Your Honor, because that was ongoing into 2021 and that was on the clip. So we would certainly seek to clarify about that. So it will open the door, and we will argue that it does.
Well, it's a short clip, and he does make reference to the fact that he has gone to the district attorney's office about all kinds of financial crimes as well. To the extent that the people believe that it opens the door to then redirecting him on evidence of financial crimes, then that certainly opens the door to a whole series of questions that I did not ask about what this district attorney thought about his testimony with respect to those financial crimes. I mean,
it's not admissible.
Look, all I'm going to say is, as with everything else, counsel, proceed at your own risk. I can't rule right now. I haven't heard the question and I haven't heard the answer, but proceed at your own risk. If the question and the answer leave the jury with an impression that may not be entirely accurate, the people will say that the door has been opened, and I will rule on that then.
I don't understand about what the people are saying, about what the court's decision is. You would have an objection to even me asking him. You were meeting with the people about more cases than just this one and having him say yes to that. I'm not trying to hide that from the jury, but if they don't...
That would be your concern with that. What would be your concern with it?
Well, I do have a concern about it. Right now, we are trying this case, and I think Your Honor has precluded all of the rest. We are talking about a tax case. We are talking about statements of financial conditions, and I think that opens the door. I just think that I wanted to bring it to the court's attention that this particular clip talks about all other financial crimes that he was involved in, and it's in their clip. If they do it, we might have to make some decisions. And that's including the question, I guess, is whether if that's out there, whether the defendants gets cross-examined on that issue. Now, I know Your Honor has made a ruling. I wanted to bring it to the court's attention. A decision hasn't been made, but I did notice it on the clip, and I think it presents some issues here.
It is on the clip, and we very much believe, and the court will hear the clip, that it's not confusing to the jury, especially if we elicit.
Let's see how it comes out.
Pardon me?
We will see how it comes out.
Yeah, sure. Understood.
Well, we can make all the arguments we want, but we don't know what it's going to look like and what it's going to sound like. So let's wait on that.
One more thing, Your Honor, and that's it. I believe the defense is offering B45, which is text from Jeremy Rosenberg and Michael Cohen. They are excerpted. How am I supposed to pronounce this?
Excerpted.
Yeah, okay.
Excerpted. Like you take an excerpt or something? Go on. You're good.
That's probably, it ain't pronounced that way in the South.
Yeah, but you also you say insurance also, so
it's too many syllables for the South, so I will allow it. we would just blur those into two.
This is a New York court of law. What do you want? We're very highfalutin here.
Overruled.
Only certain portions of the text that without context, the context that they've excerpted out are all of the very serious threats that Mr. Cohen was receiving, including some death threats that Mr. Rosenberg had to follow up on and our office had to investigate. If they are seeking to admit text of that nature, well, first of all, we object.
Sorry.
We don't think that this should come in. Your Honor had a concern about too much evidence coming in about threats to witnesses, especially because we have a jury who may be concerned. But we are going to object to the exhibit. There's one more portion on the first page that's just about the phones, which would be admissible. But the rest of it is all about Mr. Rosenberg's trying to make him feel better, given all of the threats that were happening. So we would object, and if it's admissible, we would like to put it in all of the threats.
Mr. Blanche?
Your Honor, we redacted it for the reason that people just said, that there's some back and forth around threats. The excerpts that we are offering are 100% in our view continue to go to Mr. Cohen's bias. There are accounts about Mr. Rosenberg and Mr. Cohen talking about holding President Trump accountable. I believe, and he will hold him accountable. And then a further question about the fact that Mr. Rosenberg knows about Mr. Cohen's father. We're not going to get into details about that, but it goes to show the relationship that Mr. Rosenberg and Mr. Cohen had. So much so that there's a witness, and the detective knows details, and we're not getting into details about his father. We're not getting into that. Just to point out that he had a very close relationship. As the court knows, the phones are an issue, and that's what we're trying to bring out.
What you are describing?
I am handing up.
Okay.
I can hand up the exhibits, Your Honor, the redacted and unredacted versions for you to review. Clearly, it goes to the witness's state of mind, so they can't bring in the texts that are in response to the threats, but then they can... Where am I? Because they then are not bringing in fulsome understanding of his state of mind at the time.
I agree with that. I would ask them to represent which one that we're offering is in response to a threat.
Sure. At the bottom, where on your redacted version, and I think the court can see this on the page, for some reason I stapled it wrong. I don't know. There is discussion about all about staying strong. I get it. I truly understand the incredible turmoil you must be experiencing. Mr. Cohen says, believe me, it's worse than you can possibly imagine. And you have redacted all of the threats, the telephone calls, and the calls to his wife, and the threats that he received from someone who was with an online program. So I think the judge will be able to see exactly what's redacted.
So it sounds like if what you're doing, you want to establish his state of mind and you want to establish something about the relationship, I suggest that you do something appropriate about the relationship, which is fair, which is fine. And I think the people may very well be able to elicit why the investigator was trying to comfort him and trying to reassure him.
And we will be seeking to put that in the full version. That's what we will be seeking to do.
We provided these to the people midday yesterday. I think if we would have gotten an objection to a few of the lines, like the one, if it was anticipated, we would have been able to argue to redact. I'm getting into this right away, actually. So if I could have 2 minutes, I could just make sure I take that out.
Just so the record is clear, I would say you sent me the redacted version of this exhibit at 9:38 p.m. last night. The original version I didn't object to, but the redacted version you sent me late last night when I asked for it is what I'm objecting to.
So you need to take a moment to fix that?
Excuse me?
You need 2 minutes?
Yes.
So going forward, please don't wait until I come down to discuss these things.
All right.
If you want to come down in advance to discuss issues like these, well, I can come down earlier.
Thank you.
Just 1 second before you slip away. The schedule is a little bit up in the air right now. And as you know, we have some pretty large breaks coming up because of graduations and travel plans and holidays. So at this moment, you should plan on working next Wednesday.
We should plan on working Wednesday.
It may not happen. It could be that it won't happen, but right now you should plan on it.
So that is very much fine with us. I will tell you that we have a hearing scheduled in the Southern District of Florida on Wednesday. Now, we're only part of a very small motion, and our intention was to seek permission from Judge Cannon that President Trump would be excused. In the past, she has agreed. We'll obviously state that the trial is ongoing. I do not anticipate that she will say no, but just so the court is aware that there is an oral argument scheduled. Obviously, we will. If we're sitting here, we won't be there, and I'm okay with that, and so is Mr. Bove. We have local counsel who can cover. But we will try to work out putting out the letter in today. We won't say publicly that it's before the court, So we'll be careful.
Now, when I went back and I looked at the motion in limine again, my decision on the motion, nothing has changed. If you want to make further argument, if you want to change something, that's fine. But I haven't heard anything yet at trial that would change my decision on that issue.
Understood. And we may have. I think that we're going to address it at 4 o'clock, Judge. It's a proffer from us about what we seek to elicit so we can have a sense of whether it's going to be worthwhile to do this.
All right. We will do that after the jury is excused today.
Yes, Your Honor. Yes, Your Honor. Ms. Steinglass, are you going to ask the jury about their availability on Wednesday?
Yes. So what I would normally do, I just tell the jurors, look, it's possible we may need to work on Wednesday. Would that present a hardship for any of you? If it does, raise your hand. I'm not crazy about putting them in that position, but I prefer to do that rather than have a court officer or somebody else ask the questions.
Okay.
Judge, may I raise another issue? It's very short and I
Oh,
apologize.
Another one. Here we go.
On Tuesday, some of the defense guests filed in the middle of the direct examination with some of their security detail. And I noticed that some of his guests are already here today with their security detail. But we would just ask that they not be allowed to file in the middle of Mr. Blanche's cross-examination. It's with their security detail for the jury and the witnesses to see.
Yes, I would advise that not happen.
Your Honor, I have less than zero control over what is happening on anything or anyone that's behind me when I'm crossing a witness. I don't have any control over that. I mean, they're members of the public.
Well, are you expecting anybody else today?
Your Honor, I have no idea. No, I'm not expecting anybody else, but I might be wrong.
No, well, okay.
All right.
I apologize for all the whispering. I think we may be able to get started. Was there anything else that you wanted to go over with the court?
No, Judge, thank you. There was nothing else. I just want to remind you that I asked for 1 minute to deal with something.
Sure.
Thank you, Your Honor.
Are you ready?
Yes.
All right, let's get the witness, please.
Ready for your witness, Your Honor?
Yes.
Witness entering. In comes Michael D. Cohen.
Good morning. I will remind you that you are still under oath. Let's get the jury, please.
All rise.
You may be seated.
Do both parties stipulate that all jurors are present and properly seated? Yes. Yes. Yes.
Thank you. Good morning, jurors. Welcome back. Jurors, first, I would like to apologize for keeping you waiting. I know that you were all here early just waiting for us, but we had to take care of some business, and I apologize for that. Second, as you know, our scheduling the coming week or weeks is kind of broken up by holidays and various conflicts. So if possible, it may be necessary for us to work next Wednesday. However, what I'm going to ask you to do is let the sergeant know during the next break if that creates a hardship for any of you. If any of you are unable to work next Wednesday, we just won't be able to work, and that's fine. That's okay. But it's important so that we can plan. Okay? Thank you.
May I inquire?
Yes.
Thank you, Your Honor. Good morning, Mr. Cohen.
Good morning.
So when we stopped on Tuesday, we had just started talking about an individual named Detective Jeremy Rosenberg. Do you remember that?
Yes.
Who is he?
He works with the district attorney's office.
Was he, going back a year or so to the beginning of 2023, was he one of the detectives that you interacted with for when you were coming to court to meet with the prosecutors to get your phones, that sort of thing?
Yes, sir.
And did you text with him?
I did.
And you texted with him on his work phone, correct?
I believe so, yes.
And you also texted with him on a different number, his personal phone, correct?
Correct.
Now, just to remind the jurors, Mr. Rosenberg came on 2 separate occasions in January to pick up your phones, which you had consented to the district attorney doing, correct?
Correct.
And I'm going to show you, just for you, the parties in the court and what has been named for identification as B117. And I'm going to ask that you take a look at that. And it's a couple of pages and it's redacted. I'm sorry, it's a couple of pages. So we'll flip through pages while you just take a look at it and let me know if it appears to be the text, some of the text you had with Detective Rosenberg. We can flip through it as well. Do those appear to be the text some of the text that you appear to have with Detective Rosenberg?
Yes, sir.
Now, these aren't all of the text, though, correct? Which you're looking at?
So far, no.
Judge, may we approach for a moment?
Sure.
Judge, there are addresses all over these texts, and they are not redacted.
We're not looking for or at the addresses.
I know, but it shouldn't appear for the defendant and all of those behind him, presumably.
I'll take that down.
Please
Thank
take
you.
those down.
Thank you. Sorry for jumping the gun there. Sorry.
Don't let it happen again, counsel.
Yes,
we can,
Judge.
we can take down the exhibit, please. Can we put up the redacted version B118?
B118 in private only, Mr. Blanche. That's in private only?
Yes, and we don't have to put that up there. That's my fault. Miscommunication. Can we put up B45 just for the defendant? The parties in the court. I'm sorry, the witness, the parties in the court. Take a look at this, Mr. Cohen. This is a couple of pages. We can flip through those. So do you recognize those as being, again, there are redactions, but some of the texts that you have with Detective Rosenberg last year?
Yes, sir.
And did those, knowing those redactions, do those texts accurately reflect what you wrote to him and what he wrote to you about a year ago?
Yes, sir.
The defense offers B45.
May I have a voir dire,
Voir dire.
Your Honor?
Oh, you see, you just gave away by saying voir dire, like I would say, you just gave away your northern inclinations right there. Because
In this court is voir dire, but sure.
Whether it's voir dire or voir dire is a hot dispute. That's like basically what the Civil War was all about. A lot of people mistakenly think it was about slavery or about your rights, the states' rights. No. It was all about whether it's voir dire or voir dire. So I think that matter's been settled. All right. So let's get into voir dire.
Mr. Cohen, when you say they accurately reflect your communications with Mr. Rosenberg, are there large spots that are redacted in these texts?
Yes, ma'am.
And are they therefore out of context with those unredacted portions?
I believe so.
We object, Your Honor.
Please approach. So I again sustained an objection.
Uh-huh.
I'm going to allow it in and give you an opportunity to then go back and reread it if either party wants to do it.
I think we should keep it out.
I mean, Judge, let's not use the unredacted version. By the way, Mr. Steinglass, those you were wondering, is Ms. Hoffinger's co-counsel. He's a prosecutor. Judge, let's not use the unredacted version.
Or put it in the fully unredacted version. Your choice.
I believe it's appropriate, Your Honor, on redirect. If they believe that there's something that's taken out of context that they want to offer it, that they can. But it's just that this is just the people's belief.
Except that right now we have knowledge of it in advance before it even comes in. We know in advance it's going to be taken out of context, and we know that you have an unredacted version that you can offer. I don't think it makes sense for us to just play that game. Why don't you just go ahead and introduce the unredacted version? I will sustain the objection to this document.
Thank you.
The objection is sustained.
So the text that you just read between you and Mr. Detective Rosenberg, those were around the time you testified in the grand jury in this case, correct?
Correct.
Now, and you saw text just now where you and Mr. Rosenberg, Detective Rosenberg, were discussing how you were going to hold President Trump accountable, correct?
Objection.
Sustained.
Now, you recall the leak, that there was a leak that the indictment had been returned in this case? Do you recall that?
Objection, Your Honor.
Overruled. You can answer. I'm sorry. One more time, please.
Do you recall that prior to the indictment being unsealed in this case, it was leaked to the media? Do you recall that?
Objection, Your Honor.
Can you please rephrase?
Do you recall whether prior to the indictment being unsealed, the public learned that President Trump had been indicted?
Yes, sir.
And did you yourself learn that President Trump had been indicted prior to it being unsealed in this courtroom?
Yes.
And you learned that from reading the New York Times. Is that fair?
Yes, sir.
And Detective Rosenberg confirmed it to you that the New York Times story was accurate, correct?
Objection, Your Honor.
Overruled. You can answer. I'm sorry. One more time, please.
Detective Rosenberg confirmed to you that the New York Times article was accurate and that President Trump had been indicted, correct?
Objection.
Sustained.
Detective Rosenberg confirmed that it was done to you.
I'm sorry. I just don't understand your question.
Let's put it up just for you, the court, and the people. B45 again. And if we can go towards the end, the second to last page of that exhibit and the page before for 1 minute. And now, if you can turn to the next page, you can take that down. Does that refresh your recollection that Detective Rosenberg told you that, quote, it was done, meaning President Trump had been indicted?
He identified a newspaper article.
Your testimony is that the text you just read was Detective Rosenberg identifying a newspaper article.
That's what it says. Yes.
Detective Rosenberg didn't tell you that they told the New York Times before they told you? Did he tell you that in a text?
I'm sorry. I don't understand your question. It's confusing.
Now, just to be clear for the audience here, just to let you know, what Blanche is trying to get out here is that there was a coordinated effort by Rosenberg and Cohen to let the public know that, hey, we're coming after Trump. And that's what that Rosenberg was helping leak it to the New York Times, and he was getting it, and that he was confirming with Michael Cohen, just letting him know, hey, don't worry, we got that story out to the New York Times. Did Detective Rosenberg tell you before the indictment was unsealed in this case that they told the New York Times about the indictment before they told you?
Objection.
Sustained. When you say they, who are you referring to?
Well, that was going to be my next question to this witness, Your Honor. Do you have an understanding about whether Detective Rosenberg told you about the indictment before it was unsealed?
No, sir.
He didn't tell you before there was an unsealing in this courtroom that it was done? I mean, that President Trump had been indicted?
Asked and answered, Your Honor.
Overruled. You can answer. No, sir.
Are you sure about that?
Yes.
So when did you learn about President Trump getting indicted?
From the New York Times article.
And did you have a communication with Detective Rosenberg about the New York Times article?
Yes, sir.
And what did he tell you?
He stated, well, I asked him or texted him, nice to find out through the New York Times article. Nice for a heads up.
Isn't it true that he texted you, I know you heard, and you said, nice heads up, huh? Tell the Times first?
Objection, Your Honor.
Sustained.
Did you sustain the objection?
I did.
So your testimony, sir, is that you did not hear from Detective Rosenberg before it was unsealed in this case that President Trump had been indicted?
I don't recall hearing from Jeremy Rosenberg that. No, sir.
Now, that same day, March 30th of last year, okay, you went on CNN, correct?
Yes.
And that's when you said on TV that, quote, this indictment and this case was like David against Goliath. Do you remember saying that?
Yes, sir.
And when you said that, you were describing yourself as David and President Trump as Goliath, correct?
Correct.
And you actually said on March 30th, so before the indictment was unsealed, that you had Goliath on his back, didn't you?
Sounds correct.
And that same day, Detective Rosenberg complimented you and said you were so sharp and competent, saw that fantastic interview on CNN just now.
Objection.
Sustained again.
Your Honor, may we approach?
No.
Really? Do you have a recollection, Mr. Cohen, of Detective Rosenberg texting you about your appearance on CNN?
Yes, sir.
What did he tell you in that text?
Objection.
Sustained.
Do you recall on March 31st going on TV with a reporter named Joy Reid?
Yes, sir.
And again, this is Friday, March 31st, so it's when the indictment is still under seal, correct?
Yes, sir.
And do you recall Detective Rosenberg complimenting you about your interview on Joy Reid?
Objection, Your Honor.
Overruled. You can answer. Yes, sir.
Now, that was at the same time that the Manhattan District Attorney Office was telling you not to do TV, correct?
Correct.
Now, do you recall going on your Mea Culpa podcast right around that time, March 30, 2023, and talking about the indictment?
Yes, sir.
So I want to play that for you and the parties and the court, B46. So I think you have them. Do you have the headphones there, Mr. Cohen? This is just for the parties, the court, and the witness. Okay, can you pull that up? And they played the audio tape. Were you able to hear that, Mr. Cohen? Yes. Please use the microphone.
Yes, sir.
You're really good at this, Southern. You're able to hear that. And was your voice? That was just a portion of that podcast, right? That was just a snippet, right?
Yes.
And that was on May 30th, 2023, correct?
Yes, correct.
Your Honor, we offer B46.
Just for the reasons discussed at the bench, we object.
As discussed at the bench, the objection is overruled, and we will accept it into evidence.
And if we can play that for the jury now, B46, thank you. when they played the audio tape. Now, you said on that podcast that you want to thank the Manhattan District Attorney's Office and their fearless leader, Alvin Bragg, with whom you spent countless hours. But you never met Alvin Bragg, correct?
That's correct.
Now, the reason this is critical is because a day earlier, Michael Cohen had testified that he's never met him. To this day, he's never met him. And on his podcast, he's sitting there saying that he spent countless hours with him. So that's why he wants the jury to hear this guy's just a big fat freaking liar. And what you just said about picturing President Trump being led through the booking process and whatnot, that wasn't the first time, meaning May 23rd, 2023. That wasn't the first time that you said you wanted President Trump to get a taste of what you went through, right?
Correct.
So do you remember a podcast, October 23rd, 2020, where you discussed similar things? Do you remember that?
Specifically, no, but I'm sure I did.
Well, let's take a listen. If you would just play that for the court, the parties, and the witness, if we could play B25. So, sir, if you could put your headphones on again, Mr. Cohen. Thank you. You heard the portion of your podcast again. That wasn't your whole podcast, correct?
Correct.
It was just a small portion?
Just a small portion of it.
That was your voice on October 23rd, 2020, correct?
Correct, it is.
The defense offers B25, Your Honor.
Based on the court's ruling, no objection.
Accepted into evidence.
If so, if we could play B25 for the jury, thank you. I'm going to see if I can pull up B25. Let's see if we can get. I want to see if I can get this, and we can actually hear what everyone else in the courtroom is hearing. Let me see if I get this. 16. I got. No, that's not it. 16. No. 14. No. That's not it. So difficult to find this stuff. It's not listed on the evidence that they're providing here, which is annoying. That is annoying. I want to see if I can get Adam Klasfeld. He's very good. He's very good at finding these things. Let me pull that up real quick. You guys can like talk or play music amongst yourselves here for a moment. Feel free to do that.
It's intermission.
It is.
Ladies and gentlemen, drinks are available at the bar. The lights blink. You will have 2 minutes to return to this broadcast. Joe will have B25 at that point. Also, snacks, small food items available. Don't forget to tip the wait staff. We hope you're enjoying the show so far. Take this moment to locate the nearest exits, emergency exits in the event of a fire. They're located here.
Not to be confused with B-52s.
No, yeah. Even though it may be a bomb, it will be a different sort.
Okay, let me see if we got this. I think I might have something here for y'all. This is his thread from May 16th. So now I'm going to have to like, oops, that's not the right way. This is right, okay. It's hard. This is Ann Klasfeld, who's good at pulling up evidence when it comes in. That's really the best thing about his threads. This is day 2 ahead. You have this statements of objection. No, they don't. He doesn't have it. Oh well. All right. Let's get back into it. All right. And now you said that October 23rd, 2020, right? So that wasn't around the time of the indictment in this case, correct?
Correct.
Now, in the same podcast, would it surprise you to learn that you also said that you are not going to lie, thinking about Donald Trump and his family sitting in Otisville prison makes you giddy with hope and laughter?
Sounds correct.
And so, in that instance, just to remind the jury, Otisville is a federal prison that you spent about a year at. Is that correct?
That's correct.
And you testified on Tuesday that you did not enjoy being in prison, did you, Mr. Cohen?
No, sir. It sucked.
You also said that you believe that the work that you did doing interviews with the prosecutors through interviews, your hours spent with prosecutors, your media statements, and your podcasts, you believe that you played a role in the indictment in this case, didn't you?
I took some credit. Yeah.
Well, I'm not trying to put words in your mouth. I'm not asking whether you took credit. You said, did you not, that you believe that the work that you did played a large role in the prosecutor's indictment of President Trump in this case.
Yes, that's what I believe.
And we talked about it a little bit on Tuesday, and the prosecutors asked you about it as well. But we just played two, but there are countless others from your podcast that are similar to what we just heard, correct?
I'm just going to object as to form.
Overruled. Correct.
And you continue to call President Trump various names on your podcast, and when you are doing, and when you are even doing CNN interviews, correct?
Correct.
So that's continued even up to during the trial, correct?
Correct.
I'm just gonna pause for a second, pull up some of the super chats here because I've been sending out here. I'm sorry you missed me, Chugi. I'm sorry you missed it, but yeah, next time. I told you next time, which is why I tried getting you in. Does Judaism have cults like Christianity? Yes, they're very frowned upon, but this is not at all a cult type of cult. Thank you so much, Gabby. I appreciate the super sticker. Spuds gifting 5 good Lawgic memberships. I'm gonna give you one of those horns right there for that. God bless you. And Stephen Evans also. I'm gonna give you one as well, just because I can. Welcome to the following. I kind of lost the folks who were gifted, but those of you who did, if you are one of the thousands of people who are praying and hoping to get gifted a membership and you happen to be blessed, I do think it's appropriate that you extend it. Thank you to the courteous person who was so beneficent. So those of you who are new to the following, welcome to the following. Please bear in mind, keep your arms and legs inside the vehicle at all time, and be aware that I am not the leader of the following. I am just a host. Very much, I am not the leader of the following. God bless you. Welcome aboard. Eric saying you should talk to a VTuber named Kirsch. She has hours of video on Bridge, a more insane top-down in every aspect of corporation version of DEI ESG. Okay, what we talk about? People often suggest this sort of thing to me. It's like I will try to check out Kirsch and see what they're all about. And thank you. Get 3 girls and do an oversight catfight reading. Kathy, your realtor and Judy says Southern law excellent, improve. Improv. That's what she means. Improv. That's what it is. During intermission, SL trying his best to be an annoying Jerseyite, but unfortunately he's too kind of person. Consider yourself blessed. This is true. This is really true. All right. If we could put up an exhibit, it's already in evidence 408A. Do you remember when the prosecutors showed you this? This is a truth that President Trump sent on March 15, 2023. Do you remember when the prosecutors showed you this?
Yes, sir.
Now, about 5 lines down, it says, and convicted liar and felon, jailbird Michael Cohen may have schemed up. And you testify, I believe, that was directed at you, correct?
Yes, sir.
Now, you respond to this truth, didn't you?
I'm not on Truth Social, sir.
So if we can take that down. So if I can show you just you and the parties in the court, well, we'll come back to that. Well, you don't have a recollection of responding on X to that truth?
Yes, sir.
And you responded in kind, right? You called President Trump a name right back, correct?
Sounds correct.
You called him dumbass Donald. Does that sound right?
Sounds correct.
Now, we talked a little bit about your statements during this trial that you made on your podcast and on TikTok. Do you recall on April 21st, 2023, saying on your TikTok that you have mental excitement about the fact that this trial was starting?
Yes, sir.
And that was on April 21st. That was right before opening statements in this case. Is that right?
Correct.
I think he meant to say 2024. He said 2023. Opening statements that were on the 22nd, the next morning, correct?
Correct.
And you knew at the time that there was a paralegal at the district attorney's office that was monitoring your social media, right?
I believe so, yes.
But let me just make sure I understand your answer. You did know at the time, or you believed that a paralegal was monitoring your social media?
I believe that there was a paralegal monitoring my social media.
And you knew that that was happening when you made all of the statements that you made in the past several months, including during this trial, correct?
Yes, sir.
But it certainly didn't stop you, did it, Mr. Cohen?
No, sir.
No, I want to talk about something the prosecutors talked about for a while on Tuesday, which is your prior testimony under oath. Now, you testified under oath on many occasions, right?
That's correct.
Many over the years. You've testified in depositions, correct?
Correct.
You testified before Congress 7 times. Is that right?
Correct.
You testified in a trial last fall, correct?
Correct.
We talked about your guilty pleas. There were 2 of them, correct?
Correct.
And in both of those court hearings, you testified or you answered questions under oath, correct?
Correct.
Now, was the oath that you took every single time, so going back to all the depositions, the same oath that you took on Monday morning in this courtroom?
Yes, sir.
That oath doesn't change depending on the location, does it?
No, it does not.
And you were asked to do the same thing every single time, right? You put your right hand up, correct?
Correct.
You swear to tell the truth?
Correct.
Exactly like what you did in this courtroom, correct?
Correct.
When there are times like now when your testimony lasts longer than a day, just because you come back the next day, or in this case, 2 days later, you're still under oath, right?
The judge advised me of such. Yes.
The judge reminded you that you're still under oath because of your oath that you gave on Monday morning?
Correct.
And that wasn't just here. That's happened any time that you've testified and there's been a break, whether it's overnight or even a lunch break, right?
Correct.
So in addition to the times that you testified under oath when you raised your right hand and swore to tell the truth, you've also met with federal agents, I believe, somewhere around 17 times. Does that number sound right?
Sounds right.
And each time you met with federal agents, you were told that if you made a false statement, that was a felony, that was a federal crime, correct?
Yes, sir.
So you, and just so the jury understands, that happens when the meeting starts. So at some point early on, you're in a conference room. Usually there's some agents, maybe some FBI agents, there's some prosecutors, your lawyer's there. And early on in the meeting, you're told, Mr. Cohen, you can't lie to these agents. You have to tell the truth or something like that, correct?
Correct.
Now, I want to talk about, again, your testimony in 2017 before the House Permanent Select Committee on Intelligence.
Yes, sir.
That's one of the times that you have lied under oath, correct?
That's correct.
And just so everybody is clear about how that transpired, you submitted a 2-page letter in advance of your testimony, correct?
That's correct.
And then when you testified, you kind of adopt the letter. You even read the letter into the record, right?
Correct.
And that happens after you're sworn in. You take the oath, correct?
Correct.
And on the occasions you lie about this, the Moscow project, correct?
Yes, sir.
And your lies, there are a couple of different lies, correct?
That's correct.
The number of times when you stopped the project was a lie, correct?
Correct.
You said you stopped it in January. It actually lasted a little bit longer, correct?
Correct.
The number of times you spoke with President Trump, you said was a lie, correct?
Correct.
And what was the other lie?
I don't recall. I think those
You don't recall the other lies?
were the two.
Well, did you tell the committee that you never agreed to travel to Russia and in connection with that project, and that you never even considered asking President Trump to travel to Russia, right? You testified to that, and that was not true.
True. Correct.
So those were the 3 lies that you committed when you testified in 2017, correct?
Yes, sir.
Now, just to be clear, you knew at the time that you submitted that letter and that you made those statements that you were lying under oath, right?
Yes, sir.
And you have said, and you said on Monday and Tuesday, that the reason you lied was because of your loyalty to President Trump, correct?
I said that. Yes.
But that's different. Your reason for lying is different from whether you knew you were lying, right? You knew you were lying, correct?
Yes.
And then when you met with the special counsel August 7th of the next year, right? So 2 weeks before you pled guilty in SDNY on August 7th, you met with the special counsel, correct?
Yes, sir.
And you lied again about those same 3 topics with respect to the Trump Moscow project, right?
Yes, sir.
So just as it relates to that issue, you lied under oath, correct?
Yes, sir.
And you committed another felony in the meeting with,
Objection.
I'm going to rephrase that.
Sustained.
And you lied again when you met with the special counsel on August 7th, correct?
Correct.
And you, as we talked about in November, on November 29th of that year, 2018, you pled guilty to lying to Congress, correct?
I did.
And you did not plead guilty, and you have never pled guilty to the lies in that meeting, though, correct?
Correct.
And to be fair, you were truthful at sentencing about the fact that you had lied in the meeting, correct?
Yes.
So you weren't trying to hide that from the court. You weren't trying to hide that from the special counsel. You had actually said you lied, right?
Correct.
And so when Judge Pauly sentenced you for that lie, he knew about the lie in Congress, and he knew about the fact that you had lied to the agents as well, right?
I don't believe it was Judge Pauly.
You don't believe it was Judge Pauly who sentenced you?
No, Judge Pauly sentenced me. There was the second case.
Correct. But when you were sentenced in front of Judge Pauly, you were actually sentenced for both cases, correct? So I can refresh your recollection?
Yes, sir. Yes, sir.
So meaning, what I mean by that is you're correct. The guilty plea in November was in front of a different federal judge.
Correct.
But then your August guilty plea and your November guilty plea were combined, so you could be sentenced in front of one judge.
That's correct.
And that was Judge Pauly.
Yes, sir.
And you remember Judge Pauly sentencing you to 2 months and a fine of $50,000 because of your lies to Congress, right?
Correct.
And that was to run concurrently, which means at the same time to the 36 months you got for the other crimes you pled guilty to, right?
Correct.
So when you were sentenced for that crime, your lawyers put in a sentencing memo, correct?
Correct.
You spoke to the judge?
I did.
And you said to that you were accepting responsibility for those lies for lying to Congress, right?
Correct.
But in fact, you repeatedly said, and you even said this morning and earlier this week, that the reason why you lied was because of your loyalty to President Trump, correct?
I worked with the Joint Defense Agreement, and we crafted this document, that 2-page document, in order to say one message, the message that we all knew Mr. Trump wanted, including with Mr. Trump's attorney at the time.
So you're saying that you're accepting responsibility, or are you blaming the Joint Defense Committee?
Accepting responsibility. I read it and I submitted it to the committee.
And so you talked about what you just described, right? The fact that there was a joint defense agreement and other lawyers participating in drafting that letter. And you talk about that a lot, right?
I do.
You talk about that in your book?
Yes.
And you talk about that in your podcasts?
Yes, sir.
And even at the time you pled guilty, right? So this was in front of the other judge in November. You said, when you were talking about the lies, that you made those statements up to be consistent with President Trump's political messaging and out of loyalty to President Trump, correct?
Correct.
Now, you also pled guilty on August 21st, so a few months earlier in front of Judge Pauly to a bunch of other crimes, correct?
Correct.
Now, the August 2018 guilty plea had to do with the investigation you talked a lot about from the search of your hotel room, your office, TD bank, safe deposit box, and your home, your apartment, right?
Correct.
That was after the FBI raided your home in April of that year, right?
Correct.
And the FBI took a lot of materials from you, hard copy materials, electronic materials,
Yes.
telephones,
Yes, sir.
cell phones.
Yes, sir.
Now, you knew at the time that, well, maybe not at the time, but before your guilty plea, you learned that one of the reasons why the FBI raided your home and your hotel room was because they had a cooperating witness, right?
No, sir.
You were not aware that your business partner, Gene Friedman, cooperated in that case?
I know Gene Friedman cooperated, but I didn't know it at the time. No, sir.
Well, when did you learn that Gene Friedman cooperated?
Much later.
How much later?
Approximately 2 months or so.
Okay, understood. So before you pled guilty in August, you knew that some of the evidence that the Southern District of New York had against you came from your business partner, right?
He's not my business partner. No, sir.
How would you describe him?
He was a management company, and I leased my medallions to him. I received from him a sum certain every single month, just as every one of the other 1,000 medallions that he was operating. I had no profit sharing with him. If he had losses, I would not have received any of the losses. It would be no different than if you were leasing an apartment from somebody. I had no interest in his company at all.
So you used his company, or rather, maybe he used your medallions to try and make money, and then you would get some of them as profit. Is that correct?
No, sir.
Go ahead, explain it to me.
The way the industry works is he's a licensed management company with the New York City Taxi and Limousine Commission. I own medallions, as there are 13,284 in the city of New York. He would lease my medallion or medallions with an agreement with a contract, and he would pay me a sum certain every single month, whether he made money or whether he didn't. No different than, again, leasing an apartment. If you use it or you don't, you still pay the lease.
And there were times?
Oh, I'm sorry.
Oh, no, go ahead.
He was obligated to pay all the expenses, the tax stamp, the rate card. I had no obligations regarding the vehicle. That was all his. All he did was lease the medallions, because the only way to have a taxi is you have to have a medallion affixed to the front.
Understood. And he would pay you by check every month. Is that right?
Correct.
And there were times when he didn't pay you and you had to chase him down and get your money, correct?
Correct.
There were times when checks bounced.
Correct.
And there were times when you had to go back and forth with him and say, hey, can I cash this check from you right now, or does it have to wait until Monday, correct?
Correct.
Now, just so we understand, when you pled guilty in late August, you knew that he was cooperating against you, that Mr. Friedman was cooperating against you, right?
I was told that, yes.
Well, that's what you knew means, right?
Yes.
And you, isn't it a fact he actually named in some of his paperwork associated with a guilty plea, he's taxi operator number 2, right?
Yes, sir.
So you plead guilty on August 21st, 2018. And a few minutes into that hearing, the same thing happened that happened on Monday morning. Judge Pauly had his deputy swear you in, correct?
Correct.
So it doesn't happen right away. But at some point, Judge Pauly says to his deputy, please swear in Mr. Cohen, and the same thing happens. That happened today, right? I'm sorry, that happened Monday, correct?
Correct.
And right after that, Judge Pauly actually told you that you were under oath, and that if you didn't testify truthfully, you can get in additional trouble, right?
Correct.
And then a little bit later in the proceeding, when you were talking about your conduct, you said, did you not? In the tax years of 2012 to 2016, quote, I evaded paying taxes on certain income that I received that I knew was not reflected on the return and that I caused to be filed, right?
Correct.
You also said in the same proceeding, after being placed under oath, that on or about February 2016, in order to be placed for a HELOC, a home equity line of credit, you received an application form that did not accurately describe the full extent of your liabilities, but you did not correct the inaccurate information on the form. You testified to that, right?
Correct.
Then you later testified in the same proceeding that you signed that form, the HELOC form, knowing it would be submitted to the bank as part of the HELOC application process, correct?
Correct.
You also said that you understood at the time that you were doing it, that the purpose of these documents was going to help influence the decision the bank made about your HELOC loan, right?
Correct.
And you said that in the proceeding that you understood that because of the statements I just described, you were guilty of federal tax evasion, right?
Correct.
You were guilty of making a false statement to a financial institution, correct?
That's correct.
And nobody induced you to or threatened you to plead guilty, correct?
As I stated previously, I was provided with 48 hours within which to accept the plea, or the Southern District of New York was going to file an 80-page indictment that included my wife, and I elected to protect my family.
So that's what I was getting to. So you do feel like you were induced to plead guilty?
I never denied the underlying facts. I just did not believe that I should have been criminally charged for either of those two, or should I say 6 offenses.
I want you to just focus on my questions, okay? My question was, you felt that you were kind of induced or you were put under pressure to plead guilty because you were given just 2 days, correct?
Correct.
You felt that that if you were to make a decision immediately, there was a risk that your loved one, your wife, would be indicted as well, correct?
That's what I was told.
Well, who told you that?
My lawyer.
So did the government ever tell you, did the prosecutors in the Southern District ever say, if you don't plead guilty, we're indicting your wife?
No, they spoke with my lawyer.
Well, based on so to be clear, except for what your lawyer told you, the only basis for you believing your wife was going to get indicted was that your lawyer told you, correct?
Correct.
But you said on countless occasions that the pressure of having your wife indicted and the short time frame with which you had to make a decision was the reason why you pled guilty?
Yes, sir.
But on that day, when you were under oath in front of Judge Pauly, after you raised your right hand, Judge Pauly asked you, didn't he say to you, did anybody offer you any inducements or threaten or force you to plead guilty, to enter into this plea guilty? He asked you that, right?
He did.
And you said, no.
I accepted responsibility.
Sir, I didn't ask if you accepted responsibility. We'll get to that.
Okay.
I asked whether you said no under oath to Judge Pauly that nobody had threatened or induced you to plead guilty.
Correct.
That was a lie?
That was not true. Correct.
Can we get through this? What's the difference between a lie and something that's not true?
Objection, Your Honor.
Sustained.
You said it's not true. What is the difference in your mind between something that is not true and a lie?
I said that's correct. I was just using a different terminology.
Okay, so it was a lie.
Correct.
Now, after you pled guilty in August, one of the things that happens is that you meet with a member of the court staff and they draft what's called a pre-sentence investigation report, right?
Correct.
And you did that in the federal case that you were talking about, right?
Yes, sir.
You met with somebody named Christopher Paragano?
Correct.
Did you meet with him in person or Zoom?
In person.
And Judge Pauly had told you during the guilty plea that it was important to be truthful and honest. with that individual because it helped him decide what sentence to give you, right?
Correct.
And so you met with him a few weeks later.
Yes, sir.
And even then, when you met with him and talked about the offense conduct, you blamed others, correct?
Yes, sir.
Much like what you did today. Like you explained your conduct by saying that you really didn't think you committed the tax crime, right?
Yes, sir.
You said you didn't think that you should be criminally charged for that, right?
Yes, sir.
And it actually something that the pretrial services officer was concerned about when drafting the report, that you had not accepted responsibility, right?
Yes, sir.
And then you show up for sentencing in December, correct?
Correct.
So like 5 months later about, correct?
Correct.
And you're going to be sentenced for the August guilty plea and for the false statements to Congress at the same time, right?
Correct.
And at the sentencing, your lawyers, and you put in papers and you spoke to the court, right?
That's correct.
And at that point, you told Judge Pauly that you were accepting responsibility for your conduct, right?
Correct.
And you did that, and your lawyers were asking for a low sentence, correct?
In the sentencing memo, yes.
Well, and then your lawyer spoke at the sentencing as well, right?
He did.
And that was Guy Petrillo, is that right?
Correct.
Mr. Petrillo told the court about that you had been willing to cooperate with the special counsel with the Mueller investigation, right?
Yes, sir.
He talked to the court about the fact that you were not a cooperating witness, correct?
Correct.
And the Southern District of New York had not offered you a cooperation agreement, right?
Correct.
They still wanted you to get credit for cooperating, right?
Correct.
Ultimately, the judge took all of that into account and gave you 36 months in prison, correct?
Correct.
And the fines he talked about on Tuesday,
Yes, sir.
and the 36 months in prison was lower than the recommended guidelines range, right?
Correct.
So the judge, not presumably, he said that he took into account your lawyer's arguments when sentencing you to 36 months, correct?
Yes, sir.
And then, now almost right away, right after that sentence, you started saying that you actually had not committed the tax crime you pled guilty to, correct?
No, sir.
Well, when did you start saying that?
I repeated what I had written as well with my attorney in the sentencing memo, that I take responsibility, but I did not believe that it was a charge that I should have been, that a crime that I should have been charged with. That's in the sentencing memo as well.
When you wrote a book called Revenge, you described tax charges as bogus, correct?
Yes, sir.
And in that same book, you said the tax evasion charges were 100% inaccurate, correct?
I believe I should not have been charged. Yes, sir.
So I didn't ask you whether you said you believed you should have not been charged. You should not have been charged. What I asked you is whether in your book you said the charges were 100% inaccurate.
I was referring to, again, the same thing.
But you said that, right?
I said that, yes.
In fact, in that book, you said, quote, "Now allow me to give you the real facts. The DOJ charged the tax evasion. They are all 100% inaccurate. And most importantly, SDNY prosecutors knew it," right?
Yes, sir.
And you felt and believe, I believe you still do feel, that you did not engage in tax fraud, but you had to plead guilty to protect your wife and family, right?
Correct.
You also said on TikTok as recently as April 1st of this year that the federal investigation against you was the most corrupt prosecution in at least the last 100 years, correct?
I've said that, yes.
And then on CNN very recently, March of last year, so March of 2023, you said that the lies by the Southern District of New York against me for tax evasion, I actually hope that all comes out.
Objection, Your Honor. Can we approach for a moment?
Yes.
Thank God. Judge, he is reading off a lot of documents that are not in evidence.
Okay.
Yes, he is reading from documents that are not in evidence.
Do you recall on March 30th of last year, 2023, going on CNN tonight?
Yes, sir.
I want to show you what has been marked for identification as B52. And I would ask that it would just be shown to the witness parties in the court. And if we can go to page 9 of the exhibit, take a look at page 9, and maybe if we can blow up about a third of the way down. So on that, we can take that down. Thank you. During that CNN interview that you just saw a transcript of, you said that you had hoped tax evasion charges would eventually all come out, right?
Yes, sir.
That the lies by the Southern District of New York prosecutors would eventually be exposed, correct?
Correct.
Now, you testified that you provided a lot of documents to the Manhattan District Attorney's Office, correct?
Correct. They were part of the phone, yes.
Did you also provide any boxes of materials?
Yes, sir.
not necessarily in connection with the investigation, but you provided the materials, correct?
Correct.
And you received a subpoena from the defense in this case, correct?
Correct.
And in any of the materials that you have either provided to the defense or the district attorney, did you provide proof that you have been talking about that there were documents in support the fact that there was no tax evasion?
Sorry, I don't understand your question.
Well, you say you want the truth to come out, that the prosecutor's son, District of New York, were corrupt and knew it, right?
Correct.
Have you provided any materials to anybody suggesting that the charges that you pled guilty to were not appropriate?
Objection, Your Honor.
Sustained.
So in addition to the prosecutors, you also believe that Judge Pauly is corrupt as well, correct?
Objection, Your Honor.
No, overruled. I have said that, yes.
And he's deceased, by the way?
He is.
And you believe that Judge Pauly was in on it, right?
I've said that, yes.
I just want to point out to you, the audience. Most of you who watch my show are probably awakened to the fact that and I'm not talking about Judge Pauly or this circumstance or anything like that, but just as a general conceptually, most of us tend to realize that unfortunately there is a great deal of corruption that happens in the court, in government, or various potentially courts, obviously not in the state of New York. I would never think such a thing at all. But that there's this overarching concern about corruption. That's your mindset, but that is very far from the typical New York mindset. The typical New York mindset is that those people who believe in corruption all the time are crazy, wacko conspiracy theorists.
It's okay. I'm from the South. I can say that.
Oh, okay. Well, anyhow,
It feels icky. I
the
don't
reason-
like it.
the reason I'm sharing this with you is because he's now he wants this jury of New Yorkers who assume that those people who are screaming corruption are wacko conspiracy theorists. He wants the jury to recognize Michael Cohen as being a wacky conspiracy theorist. So I have no idea at all. I have no reason to believe. I mean, let's face it, the dude lies every time his mouth opens when he's screaming that there's corruption, and that's legitimate. But the point is, maybe it is legitimate, maybe it's not. I don't know in this particular circumstance. I know nothing about his case. I'm only saying that the New York jury is likely to look at him as being a lunatic for making that claim. And that's why he wants to get out about how he's screaming corruption anytime he's being prosecuted, to make them dislike him. And that's why Todd Blanche is going down this road, to expose that where his mindset is about these charges that he pled guilty to. So
Whose witness is this?
this is the state's witness.
Oh my God, I'm so embarrassed.
This is their key witness, and they need him to be credible.
How
Because
embarrassing.
he is the only person. If you believe everything that Packer said, you believe everything. Pecker said everything that Stormy Daniels said, everything that Keith Davidson, her lawyer said, everything they testified to. None of them had any way of verifying whether or not, assuming Trump paid these monies they had no way of verifying whether these monies were paid to Cohen as part of his regular retainer agreement, or whether they were repaying him for monies he gave to Stormy Daniels. Everyone knows that he paid Stormy Daniels. The question is, did Trump pay him back, or did he not pay him back? The only person who can solidify that is Michael Cohen. Also, what Trump's mindset, assuming he was paying him back for Stormy Daniels, no one is able to testify, aside from Michael Cohen, as to why he did that. Was he motivated because he was trying to keep it from his wife, from his family? He doesn't want Barron finding out about Stormy Daniels. Was it to protect his PR in general and the public, or was it to help his election efforts? The only person who has inside knowledge as to what Trump was thinking potentially would be Michael Cohen, not Pecker, not Stormy Daniels. Stormy Daniels just knows she got a check. Davidson knows he got a check. They don't know why the check came. They don't know what his motivations were. The only the person who can pin him down on that and raise this from being potentially a misdemeanor into being a felony is Michael Cohen. So if they can decimate his credibility, so the jury says, we can't believe a damn word he says. If they come to that conclusion, then as a matter of law, practically, they cannot find him guilty of these felonies. If he's found guilty of a felony, that means that there's some credibility given to some of his testimony. And that's why they're trying to make sure that his credibility is thoroughly obliterated. That's what's happening.
There's more structural integrity in a house of cards in a tornado than this. I am embarrassed. I am so embarrassed.
This is why the DOJ, the Southern District of New York, said we're not prosecuting this case. It's stupid. That's why they said that. They're like, well, there's
They
no way
didn't
you
want to
win
be
this case.
embarrassed.
Yeah, exactly. They did not want to be embarrassed. Alvin Bragg said, "I'll take my crack at getting a felony conviction on Donald Trump." So basically, that's what we're seeing here. A couple of chats I got to get to here. Drop Barracuda says it's beneficent benefactor. All right, it's just the beneficence of the. I think beneficence worked there in that context. Are there any readings you plan on doing tomorrow night? Normally I'm at work. I appreciate you thinking of me. Thank you for reading these. I don't know how far we're going to make it today. We're at page 64 out of 237. We're already an hour and a quarter in. I have a feeling we're not going to make it very much past the lunch break, just because I have too much pity on the people who join me here to keep them here for like 5 hours and go through this whole thing. So I probably will finish this up tomorrow. So that's what it's looking like right now. And I'll invite you back, and I'll extend an invitation to you tomorrow, Chucky, if we end up doing it tomorrow. Wait, that makes no sense about the liabilities while taking a HELOC. You're getting a loan against yourself. Yeah, but they have to approve the loan. That's the whole thing. It's not medical. Nice. B52 DK HELOC on Love Shack. Love Shack. Can't wait.
There you
Can't watch
go.
the day stream, please. I need sleep. Well, tomorrow I'll probably start a little bit earlier, just when we resume there. Let me make sure I didn't miss anything over. I did miss Deus Machina Prime Trump 2024. Amen to that. Trump 2024. Let's hope that comes to be. Johnny Reb says, Joe, if you need a fourth reader, I'm available today. Samwise Gamgee on X. I did message you. I missed that. I'm sorry. Heavenly Host. I can, Joe. Yeah, I'm not going to bring in a new person right now, but maybe tomorrow. I don't foresee finishing this tonight. It's just there's too much here, and I think it's better to do it quality rather than quantity as far as rushing through it as fast as possible. I think it's a better production overall. 5 hours is nothing. Yeah, well, I don't know if I could say 5 hours is nothing when I'm bringing guests in here to help me with this. So let's get back in here.
5
All right.
hours of Southern and 5 hours of New York time is two completely different aspects of time.
Fair enough. Well said. Well said. All right. So, and you believe that Judge Pauly was in on it, right? Coming back to you.
I've said that. Yes.
Well, that's a different question. You have said it, correct?
Yes.
Do you believe that Judge Pauly was in on it?
I do.
All right, let's switch over to new reporter. You call the Southern District of New York prosecutors and Judge Pauly effing animals, correct?
Correct.
But in addition to what you just talked about, so your podcast statements, your statements on TikTok, and your statements to the pretrial services officer, you also testified under oath that you did not commit tax crimes that you pled guilty to before Judge Pauly, correct?
I stated again that I don't dispute the facts of the case, but I should not have been prosecuted. I have for the last 6 years, including in the sentencing memo, said the same thing again and again. First-time tax evader, never filing a late tax return, paying the taxes, all the money in Capital One Bank located at the base of the building I lived in, all the documents, all the bank records provided to my CPA and organized in 3-ring binders, tabulated books, which the FBI took. I don't believe that I should have been charged. I should have been given the same opportunity as everybody else. When you receive a letter from the IRS indicating that there's an issue with your taxes, I never received that. And when I never had an opportunity to meet with an agent, with my lawyer or CPA, whomever, in order to keep this civil, it immediately, within that 48 hours, went criminal.
All right, so let me ask you my question again, all right?
Yes, sir.
You testified under oath at a different trial. Now, you did not commit the crimes that you pled guilty to before Judge Pauly, correct?
Correct.
That was at a trial at 60 Center Street, right across the street from here.
Yes, sir.
And you testified on October 24th and 25th of last year, 2023, correct?
Correct.
And not to spend too much time on it, you were placed under oath just like you are here.
Yes, sir.
The judge told you that you had to tell the truth, correct?
Correct.
And do you remember being asked a question about whether you have ever made any public statements concerning the legitimacy of your conviction? And you said more than one, correct?
Correct.
And then you were asked why you did that. Do you remember testifying because there was no tax evasion? At best, it could be characterized as a tax omission.
Objection.
Sustained.
Do you remember testifying about back in October 24th about the legitimacy of your conviction?
As what I had just stated before,
Meaning what?
I should not have been charged with a tax crime.
You also talked in that trial. You also answered questions under oath about the HELOC violation, correct?
Correct.
You also said that you should not have had to plead guilty to the HELOC violation either, correct?
Correct.
Tell us why you think that.
Because while the statement on the document was not reflective, the HELOC, which stands for home equity line of credit, it is a nicer way of saying a line of credit based on your home's equity, which really wouldn't sound right. I had more than 10 times coverage. And it's not the first HELOC I've had on that property. I have had a HELOC on that property for over 10 years. I just moved it to First Republic Bank for a mortgage. And as the TD HELOC was expiring, I had asked Gary Farrow, the banker, whether or not I can get a HELOC there. So I did not believe that it was material. And that's why I said that I did not believe I should have been charged with a crime as well.
Are you finished?
I am now, yes.
When you testified under oath and pled guilty that you knew at the time that your false statements on the application would be used as a decision by the bank, were you lying?
Objection.
Overruled. I took the global plea that was provided.
Sir, please don't make a speech. It was a simple question.
Your Honor, objection.
Overruled. Please answer the question.
My question was, I wasn't looking for a global plea explanation. My question was a lot simpler than that. When you testified under oath in front of Judge Pauly that you knew at the time that you filled out these forms that the information you provided was going to be used by the bank in making a decision about that HELOC, were you lying at the time you made those statements?
Yes.
And that's because of the explanation that you gave in this courtroom just a minute ago?
Yes, sir.
So do you remember on Tuesday when the prosecutor asked you about your testimony that I'm talking about now, and the prosecutor said to you that you answered questions in response from President Trump's lawyer? Do you remember that?
I'm sorry. Can you say that again?
When the prosecutor was asking about your testimony last October on Tuesday, do you remember those questions?
I remember they were asking me questions. Yes.
I'm not asking if you remember the questions from. I'm not asking if you remember the questions from October.
Well, that's the way the question sounds.
I'm asking if you remember the questions from Tuesday from Ms. Hoffinger.
Yes.
And she said to you that you answered questions that were put to you by President Trump's lawyers in October, right?
Correct.
But the questions that you just talked about, those were when you talked about the HELOC, and when you talked about the fact that there was no tax evasion, that was in response to questions from the Assistant Attorney General, correct?
I believe so, yes.
So it wasn't just President Trump's lawyers that asked you about whether you lie in front of Judge Pauly. The Assistant Attorney General asked you questions as well, correct?
Correct.
Now, when President Trump's lawyers did start asking you questions, I'm talking about questions at trial last October 24th or 25th. Do you remember being asked whether, when you told Judge Pauly that you were pleading guilty because you were guilty, do you remember being asked whether that was a lie? And you said, yes, that was a lie.
Correct.
And you asked again. And you were asked again under oath last October whether you lied more than once in front of Judge Pauly, and you said yes.
Correct.
And you believe you did lie more than once before Judge Pauly, correct?
Correct.
You also answered a question. Do you recall that the reason why you lied was because the stakes affected you personally, right?
Yes.
And you agreed.
Yes.
And so when you said last October, was that true?
Yes.
Meaning the reason you lied to federal judge is because the stakes affected you personally, correct?
Yes.
And there is no doubt that you know what perjury means, correct?
I know what perjury means.
Now, a few months after your guilty plea, I'm sorry, we're jumping around a little bit. A few months after your guilty pleas and sentencing, you testified in front of Congress on February 27, 2019, correct?
Correct.
And the very next day, you testified in front of the Senate on February 28th. Is that right?
Yes.
And again, you were put under oath like every other time, right?
Yes.
Same exact oath. As a matter of fact, the cover art of your Mea Culpa podcast is a picture of you taking the oath, right?
That's correct.
And it was you taking the oath at one of those hearings in February 2019, correct?
Correct.
Now, when you testified in front of Congress in 2019, you testified that you confessed to your mistakes about taxes and other mistakes and plead guilty to that, correct?
Correct.
Did you tell Congress, either the House or the Senate, that actually you had lied to Judge Pauly?
I did not.
So on Tuesday, you talked about omissions. Would you agree with me that by not telling Congress or the Senate that you had lied under oath, that you were omitting important information?
Objection.
Overruled. I don't believe I was asked the question.
Well, if we can go to, again, just for the witness, the parties in the court, B518, and there's a long back and forth. When congressmen ask you questions, they go on and on, correct?
Yes, sir.
Even more than I do. If we can go page 36, page 32. And then if you can read Mr. Cohen, the bottom of page 32, and then we'll turn the page and read it into page 33.
Mr. Jordan, I thank the gentleman.
I don't want you to read it out loud. Just read it to yourself. I should have been more clear. In your answer, correct?
Correct.
You said that you took responsibility and that you take responsibility, correct?
That's correct.
And you said that you take responsibility for your mistake, right?
Yes.
You said that you were remorseful and you're going to prison.
Unfortunately, correct.
Again, I'm not prolonging this, but when you say remorseful, you're away from your family, away from your children, correct?
Correct. Yes.
But what you didn't say in that answer was that as part of accepting responsibility, you actually lied under oath, right?
Objection, Your Honor.
Sustained.
Well, did you say at any point in your testimony before Congress on either February 27th or February 28th, what you testified to last October, that you actually lied to Judge Pauly?
Objection.
Sustained.
You repeatedly say to congressmen, senators under oath over the course of 2 days that you would accept the responsibility for your conduct, correct?
Correct. And that I was going to prison as a result.
And that you were going to prison as a result, correct?
Correct.
But do you agree with me that lying under oath is not accepting of responsibility?
Can you clarify your question?
That's very confusing. Did you agree with me that when you plead guilty to a crime and you're lying, that you're not accepting responsibility for your conduct, is it?
I accepted responsibility and I was suffering the consequences as a result.
So let me ask the question again, putting aside the fact that you're testifying today that you accept the responsibility. My question is different. When you plead guilty, one of the things that you get, one of the benefits you get of pleading guilty is a little bit of time off your sentence because you accepted your responsibility, correct?
That's correct.
So when you were sentenced in December, the judge took into account that you had accepted responsibility for your crimes, correct?
I don't know what the judge made his determination on.
Well, you know that under guidelines calculation, you get time off for accepting responsibility, correct?
You do. You get a reduction.
And you got that reduction for accepting responsibility, correct?
Correct.
By pleading guilty, correct?
I pled guilty.
And for the timeliness of your guilty pleas, right?
Correct.
So my question is, again, when you got the credit at sentencing for accepting responsibility, you got that credit even though you lied. You lied to the judge when you pled guilty.
Again, I don't know how Judge Pauly made his determination. Judges, as you know, have a wide range of discretion over guidelines.
The point that Blanche is trying to make with this whole back and forth, those of you who may be a little bit confused by it, is he's trying to say that even when he's accepting responsibility, he still doesn't really accept responsibility. And the only reason he's saying he's accepting responsibility is for his own personal benefit. And he's actually lying when he does it just to personally benefit himself yet again. That even his acceptance of responsibility is just some con job that he's making under oath for the purposes of benefiting himself. And then later on he says, well, I accept the responsibility. That it's like, that everything about Michael Cohen is completely about Michael Cohen. That's essentially what Blanche is helping to elicit by this whole back and forth. I know it sounds a little confusing for most people who are listening to this, who are not used to hearing this kind of dialogue. But that's essentially what Todd Blanche is hoping the jury will recognize when they're seeing this back and forth.
Of a perjury of a perjury.
Exactly. Yeah, that every single time, it's just, and it's all about. And he said when he was on direct that he's doing it to help Trump, but clearly all of this is exclusively to help Michael Cohen himself. Let me get to a couple of things. Starlight, can we get a "Now I'm no big city"?
Now I ain't no big city lawyer, y'all.
That's awesome. That is really awesome. Wait. So they strong arm Cohen? That's delicious. Yeah. Well, that's what he says happens. I mean, I guess he was, pushed to the plea. That's exactly what I was saying about the HELOC. Oh, there you go. Bella Stella hitting us with 10 more good Lawgic memberships. Who did you bring in? Who's here? I don't even know who came in here. I got new people roaming around here. They're like, where do I go? I don't know where to go. I'm not sure what's going on here. They're all confused. Well, those of you who are brought in, and that will include Lulu Foon, Sarah, Talking Trash and Truths, David Nelson, Joseph Lawson, Driver, Ro Ken X2, Soltron, Penny, Echo 2 Papa, all of you gifted memberships courtesy of the following. Of the queen of recruitment, Bella Stella. Welcome to the following. The following is not at all a cult. Type of cult. I'm not the leader of the following. I'm just a follower just like you. Please remember. Tracksuits are not mandatory. No virgin sacrifices on Fridays. All right.
You only pet the squirrels and feed them.
That's correct. Stop punching squirrels. It's just wrong. The whole magnifying glass with the sunlight and stuff like that. We saw that happening. We put a quick end to that. That ain't happening. None of that's happening. All right.
And the only possums allowed have to be stuffed animals or crocheted.
Amen.
Only.
And never having been alive. I don't like the whole taxidermy thing either. Okay. Possums.
Correct.
Yes. Thank you very, very much. Starlight is spot on about that. I don't want to hear nothing about it with the long, skinny tails. Ew, gosh, no, it should be a fluffy tail. Ooh, fluffy. Yeah. Anyway, so thank you, Stella, for your amazing recruitment. You are awesome as always. Let's get back in. Let me make sure I didn't miss anything over here. Do a quick glance at. I'm checking my live chat over there. Show me on the top the opossum. It's funny. I don't know if you were peeking over into our locals chat, goodlogic.locals.com. But I think that is appropriate right there. Show me the top.
I thought about it because I went through the drive-thru at the bank on Friday, and the girl had a little tiny possum that was crocheted, and it would fit in your hand.
Yeah. Okay. That sounds adorable. It's just in real life. No, they should never be allowed to exist anywhere.
I think armadillos are way worse.
Do you really?
Yes.
If they didn't have a tail, you see, I've never seen an armadillo in real life.
We got some possums that live here. They're not bad. They don't bother us.
Armadillos are they're like naked mole
Possums
rats, but
look
bigger.
They look. Oh, they're like massive rats. They're massive.
Look up an armadillo.
I'm
It has an
picturing-
O at the end, not an O though.
Yeah.
Armadillo.
I know what an armadillo is. Isn't that the thing with that looks like it's got the armor on?
Yeah.
That's why it's called an armadillo?
Unless it's gotten squished.
Yeah, armadillo.
Did y'all see that South Carolina got made fun of on Saturday Night Live?
Yeah, I never
because
really
of
looked at
our
the snout of an armadillo before. That is pretty gross. Yeah, that is pretty gross.
Ours aren't really that dark. Ours are more of a
color?
brown, tannish color.
Oh, gosh. They have cute ears, though.
Ours aren't that cute. Mm-mm.
Mm.
Those kind of look cute, but ours no.
Mm.
And I think they all have some kind of.
On the magnifying glass, to get about 100. All right, let's move along here. All right. So my question is again, When you got the credit at sentencing for accepting responsibility, you got that credit even though you lied. You lied to the judge when you plead guilty.
Again, I don't know how Judge Pauly made his determination. Judges, as you know, have a wide range of discretion over guidelines. I've seen people with me while I was in Otisville who had far greater, longer tax evasion issues, who had a year and a day. So I don't know Judge Pauly's determination.
Do you think Judge Pauly would have liked to know that you had lied to him?
Objection, Your Honor.
Overruled. He can answer. I don't know what Judge Pauly would have thought.
Your testimony is that you don't know whether Judge Pauly would want to know that you lied to him?
I'm certain that he would have.
And if he had known that, that would have been something that would have taken into account at sentencing, correct?
Objection.
Sustained.
Well, if you had told him in your sentencing submission, which you talked about a lot, by the way, I lied to you. What's your understanding from all the folks you met at Otisville and everything you've been through? What's your understanding of what would happen if you put that in your sentencing submission?
Objection.
Sustained.
By the way, sometimes when you're asking a question, you don't even care if it's objected and sustained. You want the question out there to linger in front of the jury. You don't really even care about like getting an answer. The reality is, and the truth is, that there was nothing in your sentencing submission about the fact that you had lied under oath, correct?
Objection.
Overruled. No, it was not in, but the sentencing came obviously before. The sentencing memo was put in before the sentence.
Does that matter?
No.
You also were asked in sentencing whether you had reviewed the sentencing submission. You said you had, correct?
Correct.
And you had an opportunity to make a statement, and you made a statement, correct?
No, I did.
And your lawyer made arguments, correct?
Correct.
Your lawyer was asking for a sentence of time served, correct?
Correct.
But you will agree with me that neither you nor your lawyer told Judge Pauly you had lied to him, correct?
That's correct.
So you, by the way, you blamed a lot of people over the years for the conduct that you were convicted of, correct?
I blamed people, yes.
You blamed your accountant, correct?
Correct.
And at times you blamed the bank even.
Correct.
You blamed, as we talked about, the federal prosecutors, correct?
Yes, sir.
You blamed the judge.
Yes, sir.
You blamed President Trump.
Yes, sir.
Now, do you have any doubt in your mind that the outcome of this trial will affect you personally?
Could you clarify your question?
Does the outcome of this trial affect you personally?
Yes.
Did you or your lawyers, as part of your sentencing submission or what you said at sentencing, say anything to Judge Pauly about the fact that you have felt pressured and threatened by the government to make a quick decision on your guilty plea?
Did not.
So, by the way, your wife had nothing to do with the leasing agreement that you had talked about with Mr. Friedman, did she?
Some of the medallions, corporations, were in her name.
And when you receive monthly payments, were the checks made to both you and your wife, or just you, or who were the checks made to?
The corporation names.
What was the corporation's names?
Which one? There were 16 corporations.
So you had 16 corporations to collect the lease fees for your medallions?
That's
Not
correct.
suspicious at all.
I will tell you this. Everyone who hears that probably gets like a certain chill up their spine of like exactly what Starlight just expressed here about the suspicious 16 corporations. Here in New York, that is so common that it's possible that many jurors were completely they didn't blanch at that at all. And the reason is because we're used to the concept that every corporation, everything gets put into like this one entity, and that corporation handles that main asset. And if you have multiple assets, that there would be in separate things. Real property, for example, a lot of people who are developers and own, let's say, dozens or hundreds or thousands of properties, they'll put each property into a different corporation and just call the corporation 148 Madison Street, and LLC. And that,
I forget. Y'all like to sue if
Yes.
someone looks at y'all the wrong way.
Yes.
I forget. My bad.
and because
Pardon
of that,
me.
so
Pardon
that's what,
moi.
and that's why, like, if you get a judgment against one property and that corporation, that you're gonna have to fight to try and execute it against a different corporation, a different asset. So that's the reason that because it's so litigious here, and we know that you're going to be facing all the arrows all the time, whether you do something wrong or not. So that's why when we hear someone has 16 corporations, and I hear he's got medallions in this corporation, that corporation, and 16 of them, I wouldn't be surprised if he's got one medallion in each one of them. This way, if he gets sued by anyone, he doesn't have to worry that it's going to affect his other properties. So I understand that most of you probably had that reaction. It's possible that many people on the jury, if not the entire jury, was like, yeah, that's normal. So, but I don't know. I don't know what the jury's, who's on the jury, but supposedly there are 2 attorneys on the jury. Does that surprise you, Southern Law, that they accepted that 2 juries made it, the 2 lawyers would make it onto the jury panel?
Yeah, you think one side or the other wouldn't want them there, right? That's usually how it is, but not all the time.
So who do you think, if either person, who would you think that might favor?
Well, it probably depends on the lawyer, right?
That's true.
I mean, hypothetically, in this case, you might want a lawyer on the jury because the lawyer would realize this is hot garbage. And also, this witness is perjuring himself like crazy. Plus, this is all a bootstrapped set of nonsense to try and make this case from a legal standpoint with the false record. And then that supports the commission of another crime that's super vague and all that. Right. But, if it's a lawyer that hates Trump, then it could go the other way. Right. But
right.
From
and the fear is,
from a technical legal standpoint, this case wouldn't have been brought if it was anybody else. Right. That's just because it's him, whether you like Trump or not. I mean, I think that's just pretty much true.
Yeah, that's difficult to argue otherwise. I would tell you that the reason that you would be cautious about seating a lawyer is because you're reducing your jury from a jury of 12 to a jury of 1, because there's a very strong possibility that lawyer is going to get into jury deliberation and just dominate the opinions of everyone there and convince them, because everyone will sort of look at him or her as being the voice of authority. Like, here's a lawyer who's explaining the law to us, and their perspective is that this guy is guilty or this guy is not guilty, and they have a very dominating influence on the jury. So really, it's like just having some random judge who you have no idea what they're thinking, sitting there, almost very likely having an undue level of influence on the outcome of your case. And that's a scary prospect.
Yes. So, usually one side or the other or both want to bump them because of that. You don't know what you're getting for sure there.
Yeah. It's literally like, let's roll the dice out on like what this juror is going to do.
Ethically, wouldn't you have to follow ethics?
Yeah. Okay. So,
despite what your political persuasion is.
Yeah. Okay. So, and I'm confident. Well, I don't know these individuals. For all I know, they're not fellow members of the New York Bar, even if they are.
We don't. Yeah, we don't know if they're.
Yeah, I don't know anything about. I don't know who they are. I don't know what they are. That's a lot of confidence. That's a lot of confidence. I will tell you that New York did not always allow attorneys to sit on. It used to be an automatic rejection. It was in the 1990s when Giuliani was mayor that as I recall, that the law was changed in New York, and Giuliani himself was called to sit on a jury while sitting as mayor, and he sat on a jury while he was mayor of New York. So it's not something that New York always had as far as allowing lawyers on, but it has been for the last 30 years or so.
Yeah, we have it here too.
Do you?
Yeah, you can get called.
Good Logic, what are you doing wrong? Stuck at 96.5. I don't know. I can't tell you that. I don't know why I'm still stuck at 96.5. I can't explain that.
That is some deep state interference there. It doesn't make any sense.
Yep. I mean, for crying out loud.
I am not from the Low Country. Do I sound like Murda? No.
No,
that's that's Low Country.
Oh, you see, okay, yeah. She's doing a phenomenal job, really excellent. I appreciate you jumping in here, Starlight. Mary says, "Thanks, son-in-law, Starlight, doing great. Thanks, Joe, too." Both of you, phenomenal job. Cohen renamed himself as the breaker because he's the fixer who breaks. So that's
Yeah.
By the way, there's nothing. By the way, there's nothing illegal or improper about having 16 LLCs, correct?
See, we should have just kept going.
All right, there you go.
My bad. My bad.
Correct.
It's actually smart business.
It's actually standard in the industry.
And I think what he's trying to do here, he's trying to show that I don't want to mischaracterize to try and make it seem as if he's really, doing something shady by having that. And that's why I brought that up. So that's why he's trying to rehabilitate him. And it sort of strips away from the prosecuting opportunity to try and say, no, this is totally normal. And the Trump's lawyers are trying to make you look bad for something that's standard. So he probably recognizes that many jurors are going to recognize that that's standard. So that's why he's trying to rehabilitate himself. And good practice, correct? Standard in the industry?
In the Taxi and Limousine Commission, when you have what's called a mini fleet corporation, that's 2 medallions or more, you need to have them in a corporation as opposed to an individual medallion. So just as an FYI, the A through F medallions that you see, those are individuals. The other ones are generally corporations.
Understood. Thank you.
You're welcome.
Now, jumping forward to still talking about the HELOC loan, you testified that. So in February 2016, you get this HELOC loan from the bank, correct?
Correct.
And that's the paperwork that you pled guilty to being false, providing false information, correct?
Correct.
When you opened that HELOC line of credit, it had nothing to do with Miss Daniels, correct?
Correct.
So we're fast forwarding now to October, and I believe your testimony was that one of the reasons why you decided to use the HELOC was because you could hide it from your wife, correct?
That's correct. Is there any
while-
other reason?
Yeah, she wants to hide from her wife what she's doing for Trump, I guess. And what he's purportedly doing for Trump. And while her name was on the HELOC loan, your testimony is that it was paperless. So you thought that you could move the money into the HELOC, pay Miss Daniels, and your wife would not know?
Move the money out of the HELOC into the new company, what became Essential Consultants. And yes, she would not know because it was paperless.
Well, you're skipping a step, right? You would move the money from, let's say you have basically a HELOC with no balance. You're allowed to put money on it. So apply $131,000 to your new LLC from the HELOC, and then you would owe on your line of credit $131,000, right?
Correct.
And you're able to hide that from your wife because you have paperless statements of what you have, correct?
Correct.
And you didn't have to tell your wife. Well, when did you tell your wife about the HELOC?
Objection, Your Honor.
Overruled. You can answer. I'm sorry. The question again?
You testified that you didn't tell your wife.
May we approach?
Yes.
Judge, I believe there is a marital privilege. He is asking what he told the wife, and he is asking about underlying transactions. I don't think it's admissible.
By the way, this is exactly what I thought when I was doing the read from Inner City Press. I assumed it was a marital privilege objection to it, basically. On direct examination, as evidence of the crime charge, this witness testified that one of the reasons why he did this was to keep it from his wife. So, if anything, there's a crime fraud exception that talks about.
It wasn't to keep it from his wife. It was to protect his wife.
He testified it was to keep it from his wife. She is.
I never asked about communications with his wife. I asked why he used the HELOC.
There is a privilege here. It is privileged. Sustained.
There's no fraud exception. Okay. Without talking about any communications that you had with your wife, do you know whether your wife ever found out about what you did with the HELOC and the $131,000?
Objection.
Sustained.
By the way, you remember on March 9, 2018, Ms. Daniels' lawyer, Michael Avenatti, put out a public statement regarding the fact that you had paid $130,000 from the HELOC? Do you remember that?
Yes, sir.
And you issued your own statement at the time, and you said, in part, the funds were taken from my home equity loan and transferred initially to my LLC account in the same bank, correct?
Correct.
You testified on Monday, and just a few minutes ago, that you decided to do it this way. It was quick. You could move the money quickly because you wanted to conceal it from your wife, correct?
Correct.
You separately said that that on your podcast that your wife had no knowledge of the HELOC prior to March 2018, correct?
Not that she didn't have knowledge of the HELOC, that she didn't have knowledge of the transaction.
That's a fair correction. So, of course, she knew that you had a HELOC. she didn't have knowledge that what you testified about, that you moved 131,000, right?
Correct.
Now, do you know that just 2 days later, so Mr. Avenatti released a statement on March 9th, Mr. Cohen,
Yes.
and you issued a statement the same day, correct?
Yes, sir.
And then 2 days later, you know that you deleted all the text messages that you had with your wife on March 11th?
Objection, Your Honor.
Overruled. You can answer. I'm not aware of that.
Well, did you have a practice of communication, deleting communications generally, around that time, so March of 2018?
Well, I didn't have a specific practice of that. No.
But were there certain folks that you communicated with over either Signal, Dust, or WhatsApp that you encouraged them to delete your communications with them?
Yes.
Which people? Now that's shady. That's shady. 16 LLCs, to me, that's not shady. Telling people delete my stuff, that's shady.
Or
On
communicating with them on Signal, you know.
Yeah. I don't know what Signal is. I know what WhatsApp is.
How about Dust?
I don't know what Dust is either.
I don't know what Dust is.
What is Signal about? How is it different from WhatsApp?
Signal is encrypted, texting and calling. WhatsApp is what Elon Musk hopes to make X. It's what China uses. I think it's like an app that is used for everything.
So you're saying it's so there isn't much. So you're saying
It's not as functional here as it is in other places.
Oh, okay. Which people?
Well, on Signal, it does it automatically. So people like David Pecker.
Did you have a habit of asking, for example, your wife to delete her communications?
Objection.
Sustained.
Well, do you know someone named Shirlene Sachs?
Yeah, I do.
Do you recall asking Miss Sachs to delete all of her communications with you so that you would do the same?
I don't recall that specifically.
So we could show the witness, the court, and the parties was remarked for his identification as B216. Can you just take a look and see if this refreshes your recollection? We can go to the next page and the next page and the next page. And then if we can skip ahead to page 22 of this exhibit, if you see the second entry and the first entry, we can take that down. Does that refresh your recollection that you asked Ms. Sachs to delete all your communications?
Yes.
So I want to talk to you about your testimony to Congress about whether you have ever requested a pardon, okay?
Yes, sir.
On that February 27, 2019 House Committee hearing, you gave a statement on the oath that you never asked for, nor would you ever accept a pardon from President Trump, correct?
Correct.
And that was false, correct?
No, sir.
Why was that not false?
I never asked for it. I spoke to my attorney about it because we'd seen on television President Trump talking about potentially pre-pardoning everybody and putting an end to this, what I deemed to be a nightmare. So I reached out to my attorney to ask him whether or not this is legitimate.
So when you were asked, when you provided testimony, and again, same thing happened on that occasion, you had to prepare remarks you provided the committee and that you read into this record, right?
Yes, sir.
And both of those prepared remarks in writing and also when you said it on the record, on the oath, you said, and I have never asked for, nor would I accept a pardon from President Trump, correct?
Correct.
And that was on February 27th. Do you remember about 10 days later you were deposed in the House Oversight Committee?
Yes, sir.
And do you remember being asked the same question about accepting a pardon, and you saying that you directed your lawyer to explore the possibility because you were 100% open to accepting it?
Yes, sir.
Big fat stinking liar! Liar, liar, pants on fire! Sorry. And the lawyer, there are a couple of lawyers that you were talking about, right? One was Mr. Ryan, who was your lawyer, who worked with a law firm called McDermott, Will and Emery.
Yes.
And you spoke with her here named Robert Costello about the same issue, about exploring the possibility of a pardon, correct?
I spoke to Mr. Costello about that as well.
And in your deposition, so not the sworn testimony on February 27th, but in that deposition, you said that you directed your lawyers to explore the possibility of a pardon because the possibility was constantly being dangled in your face, right?
Correct.
So do you remember that right after you gave that answer, the person who was questioning you asked you to reconcile your testimony 10 days earlier, saying you never asked for, nor would you ever accept a pardon in your testimony at that deposition? Do you remember a question about how you could reconcile those two statements?
I don't.
So we can go to, well, let me see if I can refresh your recollection. We can go to what's been marked by identification as B80, just for the parties and the witness. If we can go to the first page, that is the House Subcommittee deposition from March 6th. And now, if we can just jump ahead to page 116, and if you look at the part where you are answering questions of Mr. Ratcliffe about the statement regarding the pardon. So let me know when you have a chance to read that.
Yes.
So today you testified just a few minutes ago that when you said you never asked for, nor would you accept a pardon from President Trump, you said you never did. You just directed your lawyers to do that, correct?
Correct.
When you were asked in 2019 to explain the disparity, you said they were talking about talking about the present tense. You weren't talking about the past tense when you were writing and stating that statement, right?
Correct.
So which one is it? Is it that you were talking in the present tense sense when you testified you never asked for, nor would you ever accept from the President Trump? Were you talking about the present sense, like you testified under oath 10 days later? Or were you meaning that you never personally asked for one, like you testified here today?
That I personally.
So when you testified under oath at the deposition on March 6th, that you were talking about the present tense, that was not true?
No, it was the present tense that I was not asking for it.
So is your testimony that when you said I have never asked for, nor would I accept a pardon from President Trump, when you said that, you were talking in the present sense?
Yes, sir.
But did you also mean that you didn't personally ask for it, you had your lawyers ask for it?
Yes, sir. To explore it. Because again, as I wrote, or as I stated, it was being dangled.
Yeah, I think a lot of things are dangled from this guy. But maybe I'm not being clear with my question. I'll try to be clearer. Is it that you, when you made that statement, you were speaking in the present sense, and so it was a truthful statement? Or did you mean I wasn't talking about myself, I was talking about my lawyers?
In the present sense.
So it's nothing to do with whether you directed your lawyers. You did direct your lawyers to explore the possibility of a pardon, correct?
I did.
And when you read the statement that says that you would never accept a pardon, but you directed your lawyers to explore the possibility, that's not a true statement, is it?
At that present moment, it was true. I wanted this nightmare to end. And so with it being dangled, seeing it on television, I asked them, is this really something that they're talking about? Can you find out?
And what I'm trying to understand is, given what you just said happened, what you wrote and then later said after being put under oath, that you never did that.
I'm sorry. Can you repeat that?
You just gave a story that you wanted the nightmare to end, right?
Yes, sir.
And you had been hearing on television that they were dangling pardons. So you directed your lawyer, hey, find out if I can get a pardon. I want this nightmare to end, right?
Not if I can get a pardon, if the president was going to be doing these pre-pardons.
But you testified that you were 100% open to accepting it, anything to end this, right?
Yes, sir.
And you did that with a couple of your lawyers, Mr. Ryan, Mr. Costello, correct?
Mr. Costello was never my lawyer.
Well, you asked Mr. Costello, putting aside whether he was your lawyer, you asked Mr. Costello to reach out to people in the administration, including Mr. Giuliani, about the possibility of a pardon.
And we spoke about it.
And as part of your conversation with him, you asked him to reach out to Mr. Giuliani and explore it, correct?
Yes, sir.
And so when you testified under oath less than 1 year later, on February 27, 2019, that you never asked for it, nor would you ever accept a pardon, that was a lie, wasn't it?
At the time, it was accurate.
How is that accurate?
It's not accurate.
You just said the opposite. Literally just said the opposite. No, never accept. I've never accepted it. Well, the very next day, so again, February 27th, you say, I would never ask for a pardon. March 6th, you say, yes, I would. I would direct my lawyers to find out about a pardon. And you?
Objection, Your Honor.
Sustained.
The very next day, after all that happened, your lawyer issued a statement, a public statement, that admitted that you had actually directed your attorneys at the time, to explore the possibilities of a pardon, right?
I just stated that, yes.
And they did that to correct the record from your testimony in front of Congress, correct?
Correct.
As a matter of fact, another one of your lawyers, Michael Monaco, actually sent a letter to the committee correcting your comment, correct?
Correct.
But your testimony today is that your comment was true.
The conversation was confusing for me at the time, and so we corrected the record.
The conversation? What conversation, sir?
The testimony.
Sir, this wasn't a confusing conversation. This was a pre-written statement by you that you then read into the record when the record started, correct?
Objection.
Overruled. I'm sorry, one more time.
You said that the conversation was confusing, but correct me if I'm wrong, that statement was made in writing as a prepared statement. And when you read it into the record as part of your opening statement after being sworn under oath, correct?
Correct. I was referring to what you just showed me, which was that's why I'm saying it was confusing. I thought you were referring to the comments that I just made. And yes, statement, we corrected the statement.
So your lawyers corrected the statement because it wasn't true when you made it.
Correct.
Even now he's lying. It's like, this is so sad. This is so sad. So after the FBI searched your house and your hotel and your office, you met with a bunch of lawyers, right?
I had one lawyer.
Well, you met with several lawyers, correct?
Correct.
Ultimately, you hired Guy Petrillo to be your lawyer.
Correct.
And you testified on Tuesday that you met with Mr. Costello that time as well.
Yes.
You communicate with him multiple times on the phone.
Yes, sir.
And over text.
Yes.
The first time you met with Mr. Costello was actually in Lowe's Regency where your family was staying, correct?
Correct.
You met with him and Jeff Citron, correct?
Correct.
And you knew Mr. Citron from something that had nothing to do with this, right?
Sterling National Bank.
And the reason why you met with Mr. Costello was to talk to him about whether you might hire him, correct?
Correct. He was referred to me by Jeffrey Citron.
You understood at the time, I believe you testified on Tuesday, Mr. Costello had a good relationship with Mr. Giuliani, right?
Correct.
And he told you about that?
Yes, sir.
And at that time, Mr. Giuliani wasn't representing President Trump, but he started representing him very closely thereafter, right?
Correct.
And you talked to Mr. Costello about your options, right?
Can you clarify options?
Sure. You talked to him about what you should do, what your next steps would be, given the FBI just raided your office, home, hotel, and safe deposit box.
Yes, sir.
And one of the things he talked about was cooperation, correct?
I don't recall that. No, sir.
Oh, such a big fat freaking liar. So you don't recall Mr. Costello telling you that one of the things you could do is cooperate against President Trump, correct?
Correct.
You don't think he said that, or you just don't recall?
I don't recall.
Well, do you remember telling him that you had nothing on President Trump and could not cooperate?
No, sir.
Do you just not remember, or are you not sure, or are you sure that you did not say it?
I do not recall.
The court. Mr. Blanche.
Why don't we take our morning break?
Yes, Judge.
Jurors, let's take a break. I will ask you during this break to please let the sergeant know if you're unable to work next Wednesday, okay? Thank you. I'll see you in about 15 minutes.
All right. I think lunch is probably going to be like another 15 pages or 20 pages or so. That's my hope. We're now at page 96, so we should be we're near the midway point. And we're going to stop when we hit lunch because otherwise we'll just be here for 5 hours. Colangelo says, Your Honor, one application from the people regarding the cross conducted. Mr. Blanche asked a series of questions to the witness regarding disclosure indictment. While the indictment in this case was still under seal on March 31st, we're concerned that this leaves a misleading impression with the jury because as the court knows, the fact that the indictment was unsealed by order of this court on the evening of March 30th, and there was a series of questions whether the indictment was still under seal on March 31st and later. So we requested the court takes judicial notice of the fact the indictment was unsealed on the evening of March 30th and give a curative instruction to the jury of that fact.
Mr. Blanche?
Your Honor, there was sustained objections to the fact that Detective Rosenberg told Mr. Cohen before the matter was unsealed that it is done. And that was sustained, and the exhibit is not in evidence. And there was a series of interviews that were done by this witness that he testified about before and after that date. And so, to the extent that the court either on redirect or even on cross, I can elicit the fact that the indictment was unsealed on a particular day is fine. I don't think a formal curative instruction about a couple of questions is necessary. I'm looking at the real-time transcript, Your Honor, so this may not be perfectly accurate, but Mr. Blanche asked a series of questions. Do you recall on March 31st going on TV with a reporter named Joy Reid? Yes, sir. And again, this is on Friday, March 31st, so this is when the indictment is still under seal, correct? That clearly left the impression with the jury that there was something improper about the status of his understanding the indictment. And as the court knows, the fact that the indictment was unsealed the day before, it is perfectly appropriate for the jury to be advised of that.
I think the jury should be advised. The question is how. What is the best way to do that?
I guess two options in my mind, better than the court giving instruction. I can just lead him and tell him, and we will say yes or or on redirect, that people can do that and make it clear. I don't disagree that there shouldn't be confusion on that type of issue.
Why don't we see if you're able to address it? If you are unable to address it properly, the people can do it on the redirect. I don't think it requires an instruction from the bench.
Our only concern is that this was an order of the court. We don't know if the witness was aware of the court unsealing the indictment because it was the court's own order. We think it's appropriate for the curative instruction to come from you. It can be done quickly at the end of this proceeding after this witness, and because the questions were misleading, Your Honor, we think it's important that the court correct it.
All right. Why don't you let him try to clean it up? In the meantime, you can draft a curative instruction to come from the bench. I will review it and see if I should give it. The jurors indicated that they cannot work next Wednesday, so that's off the table. Let's get the witness, please.
Witness entering.
Let's get the jury, please.
All rise. Jury's entering the courtroom.
Please be seated.
Case on trial continue. All jurors are present and properly seated.
Jurors, I'm informed that you are unable to work next Wednesday. Thank you for considering that, Mr. Blanche.
So, Mr. Cohen, before the break, so you testified earlier this morning. You were never offered a cooperative agreement with the Southern District of New York, correct?
Correct.
Same thing with the special counsel with Mueller, right?
Correct.
Same thing, you're not cooperating witness in this case either.
No, sir.
Attorney General, the trial that you testified about before the break, you were just a witness in that case as well? You were not a cooperating witness, right?
Correct.
But it's fair to say that one of the reasons that you accepted responsibility and pled guilty in August and then again in November was because you wanted to explore cooperation, correct?
Can you clarify that?
Well, did you try to cooperate? Not did you try to cooperate. Did you meet with special counsel in between the first meeting on August 7th and your sentencing?
I did.
And on several occasions?
Yes, sir.
And at those meetings, at least some of them, prosecutors from Southern District of New York were there as well.
Yes, sir.
So just to help the jury to understand that, there are two separate prosecutors. Special counsel, just from D.C., that was Robert Mueller, and then the Southern District of New York prosecutors, which are here in Manhattan, correct?
Correct.
And you're meeting with them and providing information, correct?
Correct.
But ultimately, that effort did not result in a cooperation agreement, correct?
That's correct.
And since your sentencing in December, you continued to meet with special counsel and Southern District of New York prosecutors occasionally until you showed up to serve your sentence for at least a little bit of time after your sentence, correct?
Correct.
Then we talked about yesterday. Once you were at Otisville, you started meeting with representatives from the Manhattan District Attorney's Office. So that was in August, correct, of 2018? And then since you've been released from prison technically, although a lot of that was spent on home confinement because of COVID, and you made several attempts to be released from your supervised release early, correct?
Correct.
And is it your understanding that there are all kinds of factors that go into the decision, but ultimately the judge can decide whether to grant that, whether to release you early, correct? Okay.
Objection.
Sustained. Please clarify which judge we're talking about.
So Judge Pauly passed away,
Yes.
and your federal case was assigned to a new judge.
Yes, sir.
And so when you made these motions in federal court, that was made in federal court to a new judge, right?
Correct.
And you tried that on multiple occasions, correct?
Correct.
You first tried that to be released from supervised release about 6 months or so after it started. Is that right?
No, sir.
How long after?
It was some months after, but it was not for supervised release. It was for home confinement.
Right. You testified about that yesterday. Before you were released from prison, you tried to have your prison sentence reduced as well, correct?
Pursuant to Rule 35.
Pursuant to Rule 35, which is made within 1 year of your sentencing, a judge, under certain circumstances, can reduce your sentence, correct?
Correct.
And then that didn't result in a lower sentence, did it?
No, sir.
And then when your sentence ultimately expired, you then went from being sentenced to being on probation or supervised release, right?
Supervised release.
And you're still on supervised release today?
I am.
After you started supervised release, you have made several efforts to have your supervised release terminated early. Is that right?
Correct.
How many occasions?
3.
Could it be 4?
It could be 4.
And none of those have been successful, right?
No, sir.
Now, in all 4 of those, one of the reasons stated to ask the judge to release you on early supervised release was your ongoing cooperation with law enforcement, right?
In conjunction with the first 3 included the work credits, as well as the program credits received at Otisville.
So one of the reasons were the overall circumstances of your sentence, right? That you believe that you were entitled to credits. You believe the calculation was inaccurate, but also in the judge's discretion, you wanted the judge to release you early because of your cooperation, right?
For both of those reasons, yes.
The point trying to be here that even though he's not being labeled a cooperating witness, he's hoping it will benefit him by cooperating. So that's another reason for his bias. But you never, this whole time, all the meetings, you were never offered a cooperation agreement and you were never cooperating witness, correct?
Correct.
So I want to go back to your testimony last October in a different trial, October 24th and 25th, when you were under oath and answering questions, correct?
Correct.
And you were asked questions about your cooperation. You said that you did cooperate with the government, correct?
Yes, sir.
And then you were asked a question about whether you received a 5K1 or substantial assistance letter from the government, right?
Correct.
You tell a jury what a 5K1 is?
It's a cooperation agreement with the government,
The federal government.
the federal government.
It's a motion, a 5K1 motion, correct?
Correct.
And if the motion is made by the government, the federal government, it allows the judge to give you a lower sentence, right?
Additional benefit, yes.
And you get that potentially if you're a cooperating witness.
You have to be a cooperating witness.
And you were never offered a cooperation agreement, right?
Correct.
In response to that question, on October 24th, the question was asked whether you received a 5K1 or substantial assistance letter. You said you refused such a letter, correct? Do you remember saying that?
I do.
That's not true, is it?
It's true.
So all your efforts of cooperation, the Rule 35 motion, every time you ask for early termination of supervised release because you're a cooperating witness, your testimony is that you refused a 5K1 letter is truthful?
Objection.
Overruled. Yes, it's truthful. The 5K1 concept was given to Guy Petrillo, my lawyer. That was after I had pled, after the 48 hours I was given to plead. And so I turned it around and I said, I'm not interested. Let's not even talk about it.
Who did you say that to?
Guy Petrillo, my lawyer.
So you're saying that was early on, right after you plead guilty, like in August?
If I plead guilty, yes, the concept came up and I wasn't interested. And I said, don't even bring it up.
And the concept you're talking about is acceptance of an offer of a cooperation agreement?
The 5K1,
But you get a 5K1 if you sign a cooperation agreement,
which I did not.
which was never offered to you, correct?
It was never offered to me as expressed to Mr. Petrillo. I wouldn't accept one.
So, all right, let's talk about your desire to work at the White House. You testified Monday, but also on Tuesday that you had conversations with a lot of people about working with President Trump at the White House, correct?
Correct.
And I believe you testified that you were never offered the role of chief of staff, and while you agreed that the role maybe wasn't right for you, you wish you would have been at least considered. Is that right?
I would have liked to be considered for ego purposes.
You also testified that you were offered the role of assistant general counsel at some point, correct?
That's correct.
That could have been. You would have been a White House employee in the White House general counsel's office, right?
That's correct.
Now, as part of your sentencing in December, the Southern District of New York wrote in their sentencing.
Objection.
Sustained.
Do you recall arguments being made at sentencing that you had wanted a role in the White House?
Objection.
Please approach. When you say arguments being made, what are you referring to?
So the Southern District in their sentencing submission said that there were text messages. The reason why I'm laying that foundation is because he then testifies about that in front of Congress. So Congress says, at Congress, he's asked a question. Southern District said you wanted a job in the White House. And he answers that question, and the answer was a lie.
Your Honor, you already precluded the Southern District's opinions one way or another being inadmissible in this case. So I guess I don't know what the relevance is. I guess if he wants to ask if he wanted to work in the White House, you can ask him that, but not what the arguments were.
Right. Do you feel that is an inconsistent statement?
I just want to point out here, it's a very interesting thing. I've been wondering about why this hasn't come up. Apparently, the judge, the Southern District of New York considered these federal charges against Trump, and they didn't. And you would think that would be really relevant to help the defense here to say, look, the district attorney of New York, the state prosecutor, is saying he violated a federal crime, and we're charging him with trying to cover that crime up. under New York law that it's a crime to cover up a crime. Well, the federal government knew about this crime that he's trying to help cover up, and they didn't even charge him for it. We want to tell the jury that this is not even a crime in the opinion of the prosecutors. You would think that would be very beneficial to Trump's defense. For one reason or another, I haven't researched the issue, the judge has decided not to allow Trump's team to introduce that into evidence. And it seems like they're afraid that he's getting too close to that, to laying out for the jury, make clear to them that, hey, the Southern District of New York said we have no interest in prosecuting this case. Perhaps the judge feels that their reasons for declining prosecution do not reflect on whether or not he committed those crimes, and they might lead the jury to think he did not commit those crimes. Rather, I'm just trying to play devil's advocate here and try and get in Judge Merchan's brain. So it could be that Judge Merchan is thinking that just because the DOJ, their opinion is there's not enough evidence here to prove a crime from their perspective, that doesn't mean that the crime was not committed. Just that they don't have enough evidence to prove it, and that's why they're not proceeding with it. So perhaps letting the jury know that the DOJ refuses to prosecute this crime would lead the jury to believe that he did not commit the crime, when really they should not be reaching that conclusion. It's simply that they don't feel they have enough evidence to prove the crime. So therefore, that would be a logical reason that I think would justify potentially the judge saying, I'm not going to let the jury know that the DOJ rejected prosecution of this crime. Does that make sense to you, son-in-law?
Yeah. Mm-hmm.
All right.
I mean, it's pretty devastating to the government.
It is. It's pretty devastating to the government. But the question is, like, do you think that's a fair assessment by the judge to say, just because the DOJ opines or is under the belief that it doesn't work for them, that they don't want to prosecute it, that doesn't mean he didn't commit the crime. Put Trump aside and whatever the particular facts are. Let's just talk in a general setting. The fact that one agency says we don't want to prosecute a crime, that doesn't mean the crime wasn't committed by that guy.
Yep.
And if you do tell a jury that they refuse to prosecute it, that's going to probably motivate a jury to really believe the guy did not commit the crime, right?
Yeah, it's kind of, it's probably a few things. It's, trying to have this kind of ultimate legal opinion given by some kind of outside witness, and then also a 403 thing if that's the rule they have up there, like we do.
Yeah.
The likelihood of prejudice there versus the probative value. Yeah. What does their opinion really have to do with it? On the street level, it does make sense because you realize they didn't do it because it's stupid. But if you put it into this trial, it might carry the same weight when it's really for the jury to decide whether he committed this, whatever crime it is they're saying he committed.
Right. So my point is, it's frustrating, but I can kind of understand Judge Merchan precluding it coming in. And that's what Ms. Hoffinger here is trying to insulate. So anyway, so that's why he's saying to you. So now the court is trying to ask him, maybe the reason that he should be allowed to ask this particular question is to show a prior inconsistent statement. And he's giving Trump's attorney a backdoor in on that way. So he says, so Blanche says, I can go right into the testimony and ask him to say yes or no about Southern District.
Why don't you just skip whatever everybody was arguing or saying and just get to the question? All right.
All right. So I want to direct your attention again to the February 27, 2019 testimony from the House Subcommittee. We talked about a lot about that today, okay?
Yes.
Do you remember being asked a question about your desire to work in the White House? Do you remember questions about that?
Yes.
As part of the questions, the questioners asked about certain text messages that they had reviewed that suggested you wanted a job in the White House, correct?
Correct.
And they reviewed those from a sentencing submission from December, correct?
Objection.
Sustained.
So do you remember telling Congress that it was a lie, that you did not want to go to the White House? Do you remember saying that to Congress?
I remember telling Congress I did not want to work in the White House.
Well, do you remember saying what you testified to on Tuesday is that you didn't want to go to the White House?
Yes.
And then you wanted to continue in the role of President Trump's personal attorney, right?
Yes, sir.
And you testified that every president had one, right?
Yes, sir.
You even testified about certain matters that you handled President Trump as his personal attorney while he was president, right?
Yes, sir.
But you definitively stated under oath that you did not want, when asked that question about whether you wanted to work in the White House, you said no, sir, right?
Correct.
You testified that you did not want to go to the White House, right?
Yes, sir.
And you were offered jobs in the White House, right?
I was offered a role. Yes.
You also testified that you were present when President Trump reamed out Mr. Priebus because you hadn't taken a job that you were offered, right? And that job was a job we talked about a minute ago in the White House counsel's office.
Correct.
You weren't working for Don McGahn, were you, right?
Correct.
But the truth is, Mr. Cohen, you really wanted to work in the White House, correct?
No, sir.
You didn't simply indulge friends and family about working in the White House like you testified about. You really wanted to work in the White House, correct?
Again, no, sir.
You hoped that you would be named the White House Chief of Staff, not just be considered, but be named the White House Chief of Staff, correct?
No, sir.
Are you familiar with somebody named Spencer Zwick?
Yes, sir. I know Spencer's Vic.
Who is that?
He was the fundraiser for Mitt Romney.
And that was when Mr. Romney was running for president?
Yes, sir.
Do you recall having a question with Mr. Zwick when he asked whether you want to be Attorney General Cohen or Chief of Staff, and you answered Chief? Do you recall that?
Yes, sir.
And that was still during the campaign, correct?
Correct.
And then after President Trump was elected in November, he congratulated you and he said Chief of Staff. And you said, that would be nice, correct?
Correct.
Are you familiar with somebody named Rita Vaigman?
I am.
Who is that?
It's a friend, a family friend.
She's in fashion. She's a fashion executive in New York.
Yes, sir. Actually, Florida, but yes, she relocated.
And do you recall on November 9th, so right after the election, you told her that she was going to come to the White House with you to be your assistant to the Chief of Staff. Do you remember saying that?
Yes.
And then a few days later, November 12th, so still November 2016, you had a series of communications with a family member with your daughter where you discussed whether you still had a chance at the Chief of Staff position, right?
Among other texts, yes.
Pardon me?
Amongst other text messages, yes.
And your daughter actually alerted you to the fact that she read that there was consideration Mr. Priebus would be Chief of Staff. And you said he's pushing like a madman, right?
Yes, sir.
And then there was a continued conversation about whether you still had a chance to be a Chief of Staff, and you said there was still many opportunities, right?
Yes, I think I also used the word hybrid.
And in that text exchange, you used the word hybrid.
Yes, sir.
And let's take a look at just the witness parties in the court.
It's in evidence.
We can show it to the people.
And you talked about, we'll move on. We don't need to show that. You can take the exhibit down. You talked about with your daughter, as you testified on Tuesday, about other opportunities in the White House besides Chief of Staff, correct?
Amongst other things, yes.
Are you familiar with somebody named Kadar Massenberg?
Yes, I am.
Who's that?
He's a friend of mine, a former CEO of Motown Records.
He's like a record producer?
Former CEO of Motown, yes, sir.
The same day that you spoke to your daughter about Mr. Priebus being named Chief of Staff, you had a communication with Mr. Massenberg where you, again, discussed whether you would be Chief of Staff, correct?
Correct.
You told him at that point, you just don't know, right?
Correct.
And then the next day, so do you recall on or around November 13th, President Trump picked Mr. Priebus to be the Chief of Staff, right?
Yes, sir.
You told your daughter you were disappointed?
That I wasn't considered. Yes, sir.
As you testified on Tuesday, you said that President Trump needed an insider, and that's why you weren't selected, correct?
Yes.
And your daughter was frustrated. At least she appeared frustrated over text that President Trump didn't talk to you about it before he picked Mr. Priebus, right?
I don't know if I would characterize it as frustrated as much as disappointed.
There were discussions around that time about who would be President Trump's attorney general, right?
Yes.
Oh my God, can you imagine this jackass as attorney general? And you told people you would like to be attorney general, correct?
I don't recall that.
You don't recall telling Keith Davidson that you want to be attorney general?
I don't recall if I told him that or he asked me, what about you being attorney general?
So you recall him asking that, or you just don't recall at all?
I don't recall him asking that, no. And I don't recall me telling him that's what I wanted.
And then eventually there was discussion about working in the White House counsel's office, correct?
That's correct.
You want to be named special counsel to President Trump, which was the same title you had for 9.5 years, correct?
No, sir. It was personal attorney to President Donald J. Trump.
That's what you eventually were, but I'm talking about in November 2016. Did you and your daughter have a conversation where you said you were going to ask to be special counsel to the president?
Yes, but I was referring to personal attorney to the president.
Well, you talked about how if you had that job, the pay would be very low because you'd be working in the White House, correct?
No, I think that was for a different job.
And what job was that for?
That was supposed to be assistant White House general counsel.
So your testimony is that when you said you want to be a special counsel to the president, you were talking about the job you ultimately were awarded to be his personal attorney.
No, sir.
That's what you freaking said. When you were talking, when you had this intense exchange about being special counsel to the president, that would be you working in the White House as the special counsel, correct?
If there was a role such as that, yes.
You told your daughter that President Trump told his new chief of staff that he wanted you to be special counsel to the president, correct?
Yes, sir.
And you told your daughter that would be great, right?
I'm sorry. I don't think you're characterizing this correctly at all. My conversations with my daughter was I wanted a hybrid position, one where I would still have access to President Trump, but not be a White House employee. That was what I've been asking for in the conversation with my daughter.
In that conversation, I believe we're both talking about, didn't you say that President Trump was very complimentary to you, but that he couldn't come up with a title? That was what I had been asking for. And that was the conversation with my daughter. Oh, sorry, that's the answer probably.
Yeah, I think it was.
Yeah. In this conversation, I believe you were both talking about, didn't you say that President Trump was very complimentary to you, but he couldn't come up with a title, right?
Yes, sir.
Well, you actually spoke with President Trump about that, didn't you?
No, sir. What I had spoken, Mr. Trump, President-elect Trump at the time, was to be personal attorney to the president. In fact, I brought in an attorney who truly a presidential historian.
We'll get to that. You don't recall having communication with your daughter? We're still in November. But you said you were with him now. I'm talking about President Trump, and he wants me to go, just not sure the position. Needs came up, and he told them it was complimentary, but not happy with the title I wanted. Do you remember saying that to your daughter?
Yes.
And the title is special counsel to the president, correct?
Yes.
And at the time, I know eventually you're personal attorney, but at that time, when you were having a conversation with the president-elect and with his newly named chief of staff, you wanted the title special counsel to the president, and Mr. Priebus didn't like that title, correct?
No, I believe so, yes.
And President Trump expressed some frustration that his new team couldn't find a place for you at the White House, right?
That we had not come up to a role for me in the White House, that's correct.
Didn't you, in the conversation, I believe we're both talking about, didn't you say that President Trump was very complimentary to you, but they couldn't come up with a title yet?
Right, yes, sir.
Doesn't this feel like we're
Yeah,
having deja vu?
When they switch court reporters, things got kind of interesting.
What happened? This all seems like it's the same thing. I don't know. I'm going to just keep plowing forward. Is this the same page twice? Is that what happened? Maybe. No, I don't know. I don't know. We'll keep plowing forward. Didn't you, in the conversation I believe we're both talking about, didn't you say that President Trump was very complimentary, but you couldn't come up with a title yet?
Right, yes, sir.
And then you always said that, why not special counsel? Who else would they give that to? Trump is president. He has the power to appoint anyone he wants. That's what she said to you.
Yes, sir.
And you told your daughter that you were disappointed the chief of staff, Mr. Priebus, was the one who got to pick what your role was, right?
Yes, sir.
And you felt that way in part because you took some credit for Mr. Priebus getting the job as chief of staff, right?
Yes, sir.
So part of your frustration, as you expressed to your daughter, was that now the chief of staff that you had helped President Trump pick was put in charge of finding you a job, right?
Again, my daughter may have called it special counsel to the president. The role that I'd been asking President-elect Trump for was personal attorney to the president, which is why, as I said to my daughter, it's a hybrid role. I had already had other ideas in terms of what I wanted to do, what I needed to do financially for my family.
Well, what you really said to your daughter, and I'm talking about November 14th, is that you're very disappointed that Priebus was given the power to determine my position without me. He wouldn't even be in this spot, right?
I said that.
This wasn't about hybrid. This wasn't about being his personal attorney. That was frustration that President Trump's new chief of staff was given the power to select where you were going to go, right?
Correct.
You still, even after November, were still looking for a position in the White House, correct?
Yes, sir. No, sir. I was looking for that same title as personal attorney to the president.
Such a Michael Cohen answer. Well, at that point, did you switch from wanting to work in the White House as special counsel or general counsel's office to wanting to be personal attorney?
No, I didn't want the general counsel office. I made that crystal clear. I always wanted the title personal attorney to the president. I always said there was no shame in being personal attorney to the president of the United States.
Well, early in November, Mr. Cohen, there were no communications about personal attorney. all communications about whether you would be chief of staff and then special counsel to the president in the White House, correct?
That was for my ego. Yes.
Well, 2 questions ago, you said you just want to be personal attorney, but I'm looking at text messages in November where you're talking about being personal attorney, Mr. Cohen. You're talking about wanting a job in the White House as special counsel to the President Trump, correct?
No, sir. If you look at the text, my daughter, I turn around and I state to her that I'm not the right person for chief of staff. Also, I would not expect that I would be attorney general because it wasn't within my qualifications.
But you did think you were the right person to be special counsel to President Trump. You told that to your daughter, correct?
Personal attorney with Donald J. Trump is what I wanted. Later on in the text messages, you see the clarification in that title name.
So later on, meaning in December and maybe in January, you clarified to your daughter about what you meant in November. Is that what you said?
My daughter used the title that I had at the Trump Organization, and it was always supposed to be personal attorney to President Donald J. Trump.
Are you familiar with someone named Gary Cohen?
Yes.
Who's that?
Gary Cohen was the former president of Goldman Sachs.
When you say former, did President Trump appoint him to be director of the National Economic Council?
Yes.
That was in the same period in between the transition?
The transition, yes.
You were frustrated that Mr. Cohen was named to that position, weren't you?
I had asked for Mr. Cohen.
Were you frustrated that he was named in that position?
No, sir.
You were not disappointed? You were not despondent that he was being given a White House role and you were not?
No, sir.
You testified. Well, your testimony is that you never had a conversation with Mr. Davidson where you expressed frustration about Mr. Cohen.
I stated I don't recall having a conversation with Mr. Davidson about that.
Do you recall? Now we're talking in December now of 2016. Your daughter expressed that it was ridiculous that Mr. Cohen was appointed and not you, correct?
Correct.
And she also complained that you were having a hard time getting tickets to the inauguration ball, correct?
I believe so.
Your daughter said that President Trump and his new people were walking all over you, correct?
Yes, sir.
You agreed with her that, didn't you, at the time?
At the time.
You also agree with your daughter that President Trump, and this is December, isn't doing right by you in any way, correct?
I was still waiting for the title personal attorney to the president.
And ultimately, you got that title in January, right?
Correct.
You were disappointed that after all the work you had done for President Trump for 9.5 years, nobody, including President Trump, offered you a position in the White House?
That's not accurate.
You were not embarrassed that after all the work you had done for him, you were left being his personal attorney and nothing more?
That's the role that I wanted. In fact, I asked Gary Cohen, who provided me with the attorney, Orrin Snyder. And Orrin Snyder and I, for about an hour, sat with President-elect Trump in his office, expressing the reason why personal attorney to the president was the exact role that I should play. That's the role that they gave me because was a way that I could monetize that, which I did.
Now, do you know somebody named Darrell Scott?
Yes.
Who's that?
Darrell Scott was my co-founder of the National Diversity Coalition for Trump. He's a pastor in Cleveland, Ohio.
The only event that you attended during the campaign was at Pastor Scott's church. Is that right?
Yes.
This is the one you spoke at?
The New Spirit Revival Church.
You were friends with Pastor Scott?
We became friends, yes, sir.
You knew Pastor Scott for years and years, right?
I knew him for more than a year.
Well, did you know him in 2011 when there was some talk about whether President Trump would run for presidency in 2012?
I don't recall if he was part of that.
So you recall only knowing him during the 2015-16 campaign?
I apologize. I don't recall if he was part of the 2011, but I have known him for years.
Do you all communicate on the phone?
Yes, sir.
Over texts?
Yes, sir.
And in person?
Yes, sir.
Do you recall expressing disappointment to Pastor Scott repeatedly that President Trump didn't bring you into his administration?
Not into the administration. I knew the role that I wanted to have, and I may have expressed frustration, but I don't recall.
Well, do you not recall? Well, let me ask it a different way. Did you have communications with Pastor Scott?
Yes, sir.
Let me finish. About your frustration that President Trump did not bring you to the White House.
No, I don't recall that.
Did you have communications with Pastor Scott about, even after President Trump was in the office of the presidency, about the fact that you weren't working in the White House and you weren't part of the administration?
I don't recall that.
Do you recall on National Prayer Day expressing frustration that you were sitting in your office and not in the White House with everyone else, all the people that you had worked with on the campaign? Do you recall that?
That I wasn't invited? Yes, sir.
Do you recall talking to Pastor Scott about that?
I believe so, yes.
What do you recall saying to him?
It would have been nice had I been invited, considering everybody that was part of the diversity coalition, people that I helped put together were all there and I wasn't.
Your testimony is You didn't say to him at that time, I should be working in the White House with President Trump.
Not that I recall.
Do you recall communicating with Pastor Scott regularly on the phone or with text, asking him to put in a good word with President Trump on your behalf?
Yes, I recall that.
I'm talking about 2015 and 2016. But even after the president was in the White House, do you recall that?
I do.
And you were communications with him. This is while you were working at the Trump Organization and while you were personal attorney to President Trump, correct?
Yes.
Your communications were to him in sum and substance. We're putting in a good word with President Trump so the President Trump would bring you to the White House.
I don't recall. To the White House, I knew the role again that I wanted. I had already had the idea in advance, which is what I expressed to my daughter.
Why did you need Pastor Scott to put in a good word for you with President Trump?
I knew he was going to be seeing him. While you're there, say something.
What about during the campaign when you testified that you talked to President Trump almost every day?
I did.
Why did you need Pastor Scott to put in a good word for you along that time?
It's always good to have somebody else advocate.
Were you asking him to say to President Trump about you? What were you asking to say to President Trump about you?
How important it was for the diversity coalition as a basis for the campaign and its success.
Do you recall November 2023, just a few months ago, your lawyer, not your lawyer that's here today, one of your lawyers, applied for early termination of supervised release on your behalf.
Yes, sir.
As part of that application, do you recall that there were fake cases, meaning fake legal cases, included in the letter around that application?
Objection.
Overruled.
You're going to
Yes,
love this.
Yes,
You're gonna
sir.
love this part. You're going to love this part here, son-in-law. What was your role in that situation, if you could explain to the jury?
So, as I was helping my friend who had just moved his law office for another attempt to submit papers for early termination of supervised release, I went on Google Bard, which is an AI tool, and I typed in a series of queries regarding the Second Circuit here in New York decisions on early determination of supervised release. And the reasons, because in our papers, for whatever reason, I believe we had the Eighth Circuit, and it created a whole bunch of what they call, I think, phantom results because AI wants to please the user. And I then provided to my counsel these three cases that were directly on point for why supervised release for me under the circumstances was just improper. And I provided to him, and he included it in the document. And those citations weren't accurate, not the sum and substance, but the citations themselves.
He relied on Google.
good.
Isn't that amazing? Isn't it?
Yeah.
Attorney General Michael Cohen. Oh my God. When you say inaccurate, the cases just didn't exist, correct?
Under that specific citation, correct.
But that wasn't my question about the specific citation. My question was, the three cases that you gave to your attorney were not real cases, correct?
That's correct.
And you knew that your lawyer was going to use those cases in support of your application, correct?
I gave them to him to use in support of the application, yes.
You were an attorney. Well, by that, you were disbarred.
Yes, sir.
You were an attorney for over 30 years.
Yes, sir.
And when you were practicing attorney, you did corporate and litigation?
Yes.
Part of litigation is drafting briefs, correct?
Yes.
You did that?
I did that.
All right. I wonder how long they had to pause for his laughter. I want to talk about something you testified about on Tuesday. You can just picture everyone was face palming. It's just like, oh my God, this guy's such a freaking joke. I want to talk about something you testified about on Tuesday. You testified about a phone call on October 24th. Okay, 2016. It says 2 days right before you make payment to the HELOC. And then you move money over from your HELOC to the LLC. Then you wire that money to Mr. Davidson on the 26th.
Yes.
Correct?
Yes.
You're testifying in response to conversations with the prosecutor about the phone call you had with Mr. Schiller at 8:02 p.m. on the 24th, 2 days earlier. Do you recall testifying about that?
Yes, sir.
Do you recall saying that you called Mr. Schiller on that evening because you wanted to speak to then Mr. Trump, right?
Correct.
Now, this is a very, very, very important phone call. This is, in theory, the entire case. I need to just state this because the whole issue here is that he supposedly gave this money on behalf of Trump. And it's during this phone call that he testified that he told Trump, everything is done. I took care of paying off Stormy Daniels for you. That's essentially what he said, that he got on the phone with Mr. Trump and told Trump that he got on a phone call that everything with Stormy Daniels is taken care of. And that's what he's drilling in on right here and now. Right before this is the last part, I think, before the lunch break. You recall saying that you called Mr. Schiller on that evening because you wanted to speak. So Schiller was Trump's bodyguard / assistant or whatever. He's the one who was supposedly outside the door with Stormy Daniels the whole time, like that she would see him waiting outside the door for him. You recall saying that you called Mr. Schiller on that evening because you wanted to speak to Mr. Trump, right?
Correct.
You wanted to speak to President Trump to discuss the Stormy Daniels matter and the resolution of it. That was your testimony, right?
That was.
Then you testified just a couple of days ago that you were successful. You called Mr. Schiller and you had a conversation. In that conversation, you resolved that you were moving forward to fund the deal, correct?
Correct.
Can you explain to us how that works? You know that Mr. Schiller is with President Trump, and so you know that you can call his phone and Mr. Schiller just hands President Trump the phone?
Yes, sir.
Is he on speaker? Do you usually just have privacy with Mr. Trump when that happens? Meaning, does Mr. Schiller put his cell phone on speaker and you talk to President Trump? Or does he actually give him the phone and you have a private conversation?
I've seen both.
On October 24, 2016, which one was it?
I don't know the answer. I wasn't with them.
Can you tell from your conversation with President Trump whether he was on speaker or whether you were just talking to him?
I didn't take notes.
You don't recall either way?
No, sir.
But you recall that on that call, I don't want to put words in your mouth, you discussed the Stormy Daniels matter and the resolution. And you also discussed the conversation would be that it was resolved that you were going to move forward and fund the deal, right?
Yes, sir.
That was your testimony.
Yes, sir.
So I appreciate it was a long time ago. But what would you have said to President Trump on that phone call? What would he have said to you?
Objection.
Sustained.
Because it's calling for speculation. Do you have any recollection of what you said to him on that day?
We talked about the matter, that it was resolved.
I'm not going to hold you to an exact language. When you talked about the matter, that it was resolved, is that the sort of thing that you would have said to him?
Yes.
I'm sorry. How would you have said it to him?
Objection.
Sustained.
The point is, you have a distinct and specific recollection, do you not? That on October 24th at 8 o'clock, you talked to President Trump about the Stormy Daniels situation, correct?
Yes, sir.
Now, you testified in the grand jury last March, right?
Yes, sir.
You didn't talk about this phone call in the grand jury, did you?
Not that I recall, no.
Do you want me to show you the grand jury transcript and you could check?
Objection.
Sustained.
When you say you don't recall, do you recall talking about the phone call when you met with the prosecutors before your grand jury testimony?
Objection.
Sustained.
Do you recall ever talking to the prosecutors prior to your testimony earlier this week about this phone call?
Objection.
Overruled. I don't recall.
So the first time that you recall having a conversation with President Trump on October 24th at 8:02 p.m. is when you testified 2 days ago?
No, sir. I just said that I don't recall when I spoke to the DA about that specific matter.
On Tuesday, you recall you were shown a particular call log between you and Mr. Schiller, and the prosecutor went right up to October 24th and said you had 2 phone calls that day, a voicemail and then a 1 minute and 36 second phone call. Do you remember that?
I do.
You said that was President Trump. Mr. Trump, you said that.
Yes, sir.
And do you remember being interviewed on March 7th of last year in the District Attorney's Office, which was about a week before you testified, and not saying anything about this phone call?
Objection.
Overruled. I said I don't recall. They refreshed my memory.
Let me show you what has been marked for identification as B22255. This is just for the parties, the witness, and the court. These are some notes from the meeting. You didn't take these notes, did you, Mr. Cohen?
No, I did not.
Do you see at the top of the date, March 7th?
Yes.
It started at 9 a.m.?
Yes, sir.
We can go to page 9. Please, actually, the page before. If we blow up the bottom line that says October 23rd to 25th, can you take a look at that, see if it refreshes your recollection that you didn't return the phone call?
Can we approach? Judge, this is a classic Bornholt. He is not directing. It is a classic People versus Bornholt. He is not directing his attention to where he was asked the question about it.
I don't understand what the objection is.
The objection is that you tried to impeach him with an admission, but you haven't established that he was asked the question about it.
People versus Bornholt.
Your Honor, that's not what this is showing. They walk through every day, and he talks about what he remembers for each day. As a matter of fact, on the 26th, which I'm about to show him, he has a specific recollection of telephone calls with Trump. on the 23rd. And to the 25th, there's a dash, verbatim, writing of everything that he is saying. There's no question and answer. It's just giving an explanation of what he remembers.
Which is exactly why he may have not have been asked the question.
That's why we have Bornholt to ensure that people are not impeached simply because they forgot to say something. You have to establish that he was asked the question, that he was directed to a particular area, and they failed to, given the opportunity, they failed to reveal it.
If we can put back up 255, just for the witness, the parties in the court, go to page 8. Can you take a look at that, Mr. Cohen, and see if it refreshes your recollection about whether you were asked any questions about the phone call on the 25th?
Yes, sir.
Does that refresh your recollection about whether you were asked any questions about phone calls on the 24th?
No, sir.
And you have no independent recollection of that meeting that would answer that question?
I do not.
Now, if we can look up the next page of those notes and below at the top, if you look at the third line, it talks about calls between you and President Trump on the 26th, correct? 2 days later?
Objection.
Why don't you direct his attention and have him read it?
Take a look at the third line. If you can read the third and fourth line.
Is there a question?
Does that refresh your recollection that you did talk on that date about phone calls with President Trump on the 26th?
Objection.
Sustained.
Do you have a recollection of talking on that day with the prosecutors about phone calls with President Trump on the 26th?
Objection.
Overruled. Yes, sir.
And you did, right?
Yes.
Do you remember? I appreciate this goes back a while. Do you remember at the time, October 22nd, 23rd, 24th, 2016? You were receiving a bunch of ongoing and continuing harassment phone calls. So somebody was calling you constantly. Do you remember that?
Yes, sir.
And do you remember that on the 24th at around 7 o'clock at night, the person who was harassing you forgot to block his number? And you got that number. Do you remember that?
No, sir.
Let me show you what has been marked for identification just for you, the court, and the parties as B165. We're going to highlight some of this for you. If we can highlight just the first couple of texts. So if you see just, this is just for you, but do you see the number, and that's you, then a number that ends in 0594. Do you see that?
Yes, sir.
Do you see that your text to this number, it says, this number has been sent to Secret Service for your ongoing and continuous harassment to both myself as well as to the organizations named on it.
I do.
That's at 7:10 p.m., right?
Yes.
And then the next text back says, it wasn't me. My friend told me to call. I'm sorry for this. I won't do it again, right?
Yes, sir.
And you respond and say, they're going to have to explain that to the Secret Service because you have been receiving dozens of these harassing calls over the past 3 days, right?
Correct.
If you're a minor, I suggest you notify your parent or guardian of that. That's what you said to them, right?
I did.
The person texted you back and said, I didn't do it. I am 14. Please don't do this. And you asked them to have their parent or guardian contact.
Objection. He is reading from the document.
Sustained.
You eventually said to have their parent or guardian contact you?
When they expressed they were 14, I felt it was proper.
That was at 7:24 p.m. on the same date, October 24th, right?
I'm sorry, what time?
The last text was at 7:24 p.m.
Correct.
So that whole exchange was between around 7:10 and 7:24 p.m.
Correct.
That was an exchange because you had been receiving a bunch of harassing phone calls the prior 3 days.
Correct.
Do you recall at 7:48 texting Keith Schiller about this 14-year-old? Do you recall that? Do you recall that?
I don't recall.
Do you recall texting Keith Schiller at 7:48 p.m., quote, who can I speak to regarding harassing calls to myself and office? The dope forgot to block his call on one of them. You don't recall that?
It sounds right. Yes, sir.
Let's take a look. If we can show the witness B266, just the witness, the court, and the parties. This is a series of texts between you and Mr. Schiller on the same date. You said, who can I speak to regarding harassing calls to my cell and office? The dope forgot to block his call on one of them. Do you see that?
I see it.
Mr. Schiller says,
Objection. Reading a document, not in evidence.
Sustained.
do you recall at 8:02, your initial text to Mr. Schiller is at 7:48, and then at 8:02, he says, call me to you, right?
Yes, sir.
So we can put up what's already in evidence as Exhibit 341 on screen, please. These are the phone calls between you and Mr. Schiller, right? And if we go up to the second page, I'll highlight at 1024, the 801 and 802 calls, please. Do you see? If you can highlight the 1024, the 801 and 802 calls, I see them. That's fine. That shows a voicemail, 801 from Keith Schiller to you.
Yes, sir.
And then at 8:02, he says, call me. And then it looks like you then call him at 8:02 for 1 minute and 36 seconds, right?
Correct.
If you look at the call me text, if we can take it down for a second part and put back up B166, which is your text message from that day, you'll agree with me that Mr. Schiller told you to call him at 8:02 and 21 seconds, right?
Yes, sir.
And so you called him back. And we can go back to the phone call chart on 341 and highlight the bottom. You called him back at 8:02. It was likely after 8:02 and 21 seconds, right?
That's correct.
This is the call that you testified about on Tuesday, that you had conversation with President Trump, that you called Keith Schiller. It wasn't to talk to Keith Schiller, it was to talk to President Trump about the Stormy deal. And moving forward, that was your testimony.
Yes, sir.
Let's take a look at what happens next. Let's go back to B166 804. You text Mr. Schiller the number.
I'm going to object to reading a document that is not in evidence.
It's not in evidence.
I will, Your Honor, I will offer B166 in evidence.
Any objection?
I think he just needs to lay a foundation.
Hold on a second here. Let's see if I can pull up B166. I think this is here. Back. This is what he's talking about here. We're going to speak to regarding the calls. So you can see that this is 7:48, and then he reads that at 8:02:15.
How embarrassing.
This is the phone call. That he lied to this jury. That's what this he just showed him. The very critical call that he says the purpose of that call was to talk to Trump about Stormy Daniels is now being exposed, that the objective of that call was actually to deal with some stupid 14-year-old prank caller. And that he lied to this jury. This is devastating.
That's
devastating.
crazy.
It's unbelievable that he has the audacity to lie about what he remembers that call being about. And now it's being shown that he has this whole text conversation. Thank God he had the text conversation to establish that his claim about that call at 8:02 was an outright lie as to what the nature and purpose and who he was even talking to. He probably wasn't even talking to Trump at all. He's probably just talking to Schiller. Schiller says, call me. Unbelievable.
The Hoff has just said,
Yeah.
Okay.
It's really unbelievable. This is the end of my Cohen's testimony right here. I mean, it's not the end of it. I'm saying this decimates anything that any substance he was able to provide. You see the text you're looking at, B166 between you, Mr. Schiller. You can look at the first page too. Please highlight the top of the page. See, it says Cellbrite. It has your number, Mr. Schiller's number.
Yes.
We offer B166.
with redactions.
If you can make the necessary redactions.
We'll redact it, of course, absolutely. For now, can it be shown to the jury and not in the courtroom?
I don't know if you can do that. We were told that we can. It is being shown to the jury, but not anybody else in the court.
Let's take a look at it with the jury, just to go back to the conversation between you and Keith. Who can I speak to regarding phone calls to my cell and office? The dope forgot to block me one of them. That was 7:48. At 8:02, he said, call me. I can put it back up again. At 8:01 is when he leaves that voicemail.
Yes.
You call him back at 8:02 for 1 minute and 36 seconds. At 8:04, you text him the number of the 14-year-old who was prank calling you, correct?
I did, yes.
Immediately, he texted you back. Within a few seconds, he said, okay.
Yes, sir.
The very next morning at 7:58 a.m., you said, did you reach the family, right?
Yes, sir.
Let's take that down. When you testified on Tuesday that you had specific recollection that 1 minute and 36 second phone call on October 24th was not with Keith Schiller, that you called Keith Schiller and he passed the phone to President Trump. You finalized the deal with Stormy Daniels and you said, we're going to move forward. And he said, yes, because you kept him informed all the time. That was your testimony, right?
That's correct.
That was a lie. You were actually talking to Mr. Schiller about the fact that you were getting harassing phone calls from a 14-year-old, correct?
Part of it was the 14-year-old, but I know that Keith was with Mr. Trump at the time, and there was more than potentially just this. That's what I recall based on the documents that I reviewed.
5 minutes ago, I asked if you remember harassing phone calls, and you said no. And then I refresh your recollection. It's totally fair if you don't remember, but now your testimony is that you were testifying truthfully on Tuesday to a 1 minute and 36-second phone call. And you had enough time in that 1 minute and 36 seconds to update Mr. Schiller about all the problems you were having with these harassing phone calls, and also update President Trump on the status of the Stormy Daniels situation, because you had to keep him informed, because every time you made any decision, you ran it by the boss. That's your testimony?
I always ran everything by the boss immediately. And in this case, it could have just been saying everything is being taken care of. It's going to get resolved.
That's not what you testified to on Tuesday. You said you had recollections of a phone call on October 24th at 8:02 p.m. where you called Mr. Schiller and he gave the phone to President Trump, and you told President Trump about the updates, that you were moving forward with the funding, and he said, okay, go. That was a lie. You did not talk to President Trump on that night. You talked to Keith Schiller about what we just went through. You can admit it.
No, sir, I can't. I'm not certain that's accurate.
You were certain it was accurate on Tuesday when you were under oath and testifying. You were certain it was accurate. You had a phone call to President Trump, but now you're saying you're not certain it was accurate.
Based upon the records that I was able to review in light of everything that was going on, I believe I also spoke to Mr. President Trump and told him everything regarding the Stormy Daniels matter was being worked on, and it's going to be resolved.
We're not asking for your belief. This jury doesn't want to hear what you think happened.
Objection.
Sustained.
I want to put up People's Exhibit 262. It's in evidence. So you may recall that people showed you this exhibit, and you testified that these were certain text messages between you and Mr. Schiller. It spans March 4, 2016 to November 4, 2016. Do you see the exhibit?
I'm sorry, one more time, the dates.
The dates, I believe, if we can blow up the last one, to March 4, 2016 to November 4, 2016.
Yes, sir.
You were shown all those texts by the prosecution?
Correct.
If we can focus in on October timeframe on this exhibit, the people include the text messages that I just showed you between you and Keith Will Schiller on October 24th on this exhibit?
Yes, sir.
You see those text messages on that exhibit?
I don't.
People did not bother to include those on this chart, did they?
Not on this chart, no, sir.
When they prepped you and they showed you this chart, right? They prepped you and showed you this chart. You didn't see this chart for the first time on Tuesday, did you?
Objection.
Sustained.
When they prepped you, did they show you a chart?
Objection.
Sustained.
Have you ever shown in prep the text that I just showed you between you and Mr. Schiller about the harassing phone calls?
Objection.
Overruled. No, sir.
The first time you had seen those texts in 7 or 8 years was just a few minutes ago.
Yes.
Given that your testimony to this jury is still when you specify what you testified on Tuesday, you had specific recollection of a phone call with President Trump on October 24th at 8:02 for 1 minute and 36 seconds that you were telling the truth?
Based upon what was going on and based upon the other text messages and so on regarding the Stormy Daniels matter, yes, I believe I was telling the truth.
So you were not basing your testimony on Tuesday based upon your memory. You were basing on documents that the people showed you in prep. Is that your testimony?
That refreshed my memory. Yes, sir.
Was that true for just phone calls, or was it true for other phone calls too?
I don't recall telephone calls on a specific date going back to 2016. Based upon the records and based upon the documents that you were reviewing.
Mr. Cohen, you just said that you don't recall phone calls back in 2016. That is not what you testified to on Tuesday. On Tuesday, you testified that you remembered the phone call.
Objection.
Sustained.
Is now a good time for a break?
Jurors, let's go ahead and take our luncheon recess. Please remember all the admonitions. Please do not discuss the case either among yourselves, with anyone else, et cetera, et cetera.
All right, you can step down, and that's it. All right, we're gonna stop. We're gonna take a break here for the night. So
that's crazy. That's absolutely insane. That's
unbelievable,
bananas.
right?
That should be directed verdict. I mean, just throw it out.
Right there, right
Yeah.
there. It should have been directed verdict.
Yeah.
Like your key witness who ties everything together for you just admitted that everything he everything he said he doesn't even know if it's true, and he forgot the key phone call that he forgot that the reason he was spurred to call was because Keith Schiller said, "Call me about this 14-year-old who's harassing you," and that he spent only a minute and 36 seconds. Not he spent 10 minutes on the phone. In a minute and 36 seconds, and he managed to update and give the pivotal information. I mean, it's just and he left that out on direct. The only time he remembered that was even related was when he was shown this text message conversation, that there was even that whole issue going on, and he forgot about it completely until he was shown to him on cross. It was phenomenal. That's why when they came out of lunch break, all the reporters were basically tearing their clothing and wearing sackcloth, because it's like, he's effed. I mean, this is not, he's complete. This whole case was just, I mean, is this case not completely screwed?
It's rare you see something that bad.
Yes, this is a Perry Mason moment right here.
Oh yeah.
This was a great Perry Mason moment. Let me get to a couple of chats here, and then we'll kick on out of here. A state should not be allowed to prosecute for a federal crime. I mean, it's technically a state law that's protecting that you breaking this law, you're doing something wrong in trying to conceal a crime. This is the first time New York has ever prosecuted that the predicate crime that you're trying to conceal is a federal crime. New York has never done that before, which is one of the issues that people have with this case. Sounds a lot like Dwight Schrute's assistant to the region manager. It does sound a lot like that. That his role was he was asking someone if he wanted to be assistant to the chief of staff. Okay, let me make sure I just didn't get anything over on that. I got everything on locals, and then we'll just. You want to tell people what's going on with you, Southern Law, before we get on out of here?
And like you said, not much on YouTube right now due to some cases that I'm working on. You can't talk about the cases you're doing typically. And
right.
Boy, did it get busy. I have to tell you that offline sometime. Yeah,
I'll tell you right now. You were both really, really phenomenal. I can't thank you enough. I'm gonna put you in the description here so that people who want to find you can find Southern Law. And please, I'm going to urge you guys, if you can join over there. Let me just actually do this now with Southern Law. I don't think I put you in the description. There you are. So you'll find him in the description there. If you guys can please click on over, it's in the description now. If you click on over and subscribe to me, I'd be most appreciated. And thank you so much. Joe put in the Gator and Litigator. Yeah, no, that trust me, that's a fun cross to do.
Wow,
that was fun cross.
Yeah.
that is a fun cross to do. Anyway, Starlight, I want to thank you for joining as well. You were phenomenal. And
thank you. I was like, are you serious?
You asked for it. You asked to come in there. So yeah, I don't know if you're available.
Judge put me up to it.
Yeah. Son-in-law, I don't know if you're available tomorrow. I would certainly be happy to have you resume your role for the afternoon session of day 2, which I plan on covering tomorrow night. But you can let me know behind the scenes if you're available. If you're not, I don't want to lock you in right now, because you might be punch drunk at 2:00 in the morning and not thinking straight, and maybe it'll depend on what time I start.
This is past my normal bedtime of 9 p.m.
Right. I normally start after 9 p.m. That's true. And if you're working hard, you're probably not going to. I'd be happy to have you back tomorrow, but if you can't, whatever it is with respect to tomorrow, you were phenomenal. Both of you were really, really phenomenal. If you're still here, which it seems like there's a couple thousand you still watching this, I would urge you to please make sure you hit like and subscribe. And technically,
you can join me in locals and the Discord.
You can join me in locals at goodlogic.locals.com. Mandy, you want to shill something? I'd be happy to give you a moment to shill something.
Look into the South Carolina cicadas, or like Joe likes to say, cicadas.
The cicadas. Yes. Okay. All right. Is there somewhere people can find you, Starlight?
Just South Carolina.
All right.
But not the low country part, though. Not the low country.
No.
Nowhere near Murdoch. No, she's free.
No.
All right.
That's where Haley's from. Haley's from that part. I try to stay away from that part.
We gotta make it a segment and get you all VTuber models. Maybe that's a thought. I don't know. We'll look into it. I thank you both for joining me. I thank everyone for watching. Please make sure you like and subscribe. Head on over to goodlogic.locals.com, where you can find out what time we're starting and everywhere that I'm appearing on Spaces or various local appearances that I make where I do special exclusive content for locals. I really appreciate if you can join me over there. Goodlogic.locals.com. Do you have a locals also, Southern?
No. Mm-mm.
No, all right. So this guy's busy doing real lawyering. And if you want to support me on my efforts to ungag Trump, go over to givesendgo.com/ungag Trump. I'd be most obliged on that. Hopefully, we're going to be having oral arguments this week. So that should be developing as well. I thank you all for joining me. Make sure that no matter what you do not eat the bugs. As always, have a good night and Godspeed.